We'll now convene the meeting of the Labor and Public Employees Committee meeting, and I am going to take a brief pause since I don't have the link for Zoom in my computer. So I'll get that fixed in a minute. We'll start. Good morning. We will now start with item number 2 on the agenda, remarks by the chairs. And this is our second JF meeting and looking forward to, I think it's our second or third. I can't remember. Third, okay. And I'm looking forward to getting some work done today. Any comments by our ranking members? Okay, let's get started then. We'll start with item number 1 on the agenda, House Bill number 6842, an act concerning the minimum fair wage in persons employed at cannabis establishments. This is a JFS to the floor, LCO number 6614.
So moved.
Second.
It's been moved and seconded. This bill prohibits the labor commissioner from counting tips as part of the minimum wage requirement for employees at cannabis establishments, dispensaries, or producers. It also specifies that any cannabis establishment, dispensary, or producer that pays an employee less than the state minimum wage is violating the minimum wage law. And the S language moves these provisions, codifies them in the cannabis statutes rather than the wage and hour statutes. Any questions? Comments? Representative Canino.
Thank you, Madam Chair. So I'm just trying to wrap my head around the change that we're making here. With this change in this legislation, if a cannabis company wanted to become a tipped establishment, would that still be allowed? Would they still be able to, let's say, apply to the Department of Labor to have engage in a tipped model with their employees, or does this close off that possibility completely?
It's my understanding by including it here, we're saying that they are not allowed to use tip credit in their minimum wage provisions. I believe if they were seeking to change their model, and really we're moving toward a restaurant type establishment, we would probably have to review that here in this committee again.
Thank you for that answer. That gives me some concerns because individuals and businesses can get very creative with their employment structure and with the compensation model that they want to provide for their staff. And some staff might even agree that a tipped model might be more beneficial to them. And if later on down the line there are different avenues for these businesses to operate in, whether they do have a cafe or a restaurant model, or even if they just continue operating in the same dispensary model that they have right now, and we get to a point where individuals are receiving much higher tips than they are now, then they should have that flexibility to be able to engage in whatever type of payment structure that both the employer and the employee consent to. If this were just making a clarifying change that you cannot automatically assume that a cannabis company can be a tipped environment, then that's one thing. But I would like for there to be an avenue for a company to maybe apply or to demonstrate that their employees are receiving an adequate amount of tips to get them to that wage that would be sufficient over minimum wage. And for that reason, I'm going to have to be against this today, simply because it is further violating the employment negotiation process of employers and employees in the state. So thank you very much.
Thank you, Representative Canino. I do want to clarify for the record that at this time, there is no application process for any other employer other than a hotel or a restaurant to apply for through DOL. So this is not changing anything that currently exists. As it exists, whether this was in the minimum wage bill statutes that are under DOL or whether it's in the cannabis, they do not have that ability to apply for a tip credit. So this isn't changing anything in statute. And as I said earlier, if any establishment wants to change and become a tipped, an establishment that is eligible for tip credit for its employees, they would have to change the law as it currently exists, whether it's under DOL or whether it's under DCP, either statute. So we're not changing anything here, but we do think it's smarter to put this in the cannabis section to make sure there's no confusion in our DOL statute, which is that you're only allowed to apply for tip credit if you are a hotel or restaurant. Any other comments or questions? Senator Sampson.
Thank you very much, Madam Chairman. Good morning. Just listening to this conversation, I guess what I'm asking right out of the gate is what's the reason, the impetus behind this bill? I was under the understanding is because this is going on somewhere in our state. Am I wrong about that?
There was an occasion where this occurred.
Thank you. And were those folks found in violation of current labor law?
They were.
Okay. And as a result, what does that negate the necessity for such a policy change here if it's already not allowed for someone outside the restaurant and hotel industries to engage in the tip credit type employment payment scheme? And of course they were already dealt with as far as the Department of Labor goes. Maybe you can explain why we feel like this is still a necessity if that's already occurred.
I don't believe this is a change in policy, but I do believe it's necessary to clarify it. And we often hear from people on both sides of the aisle that our laws should be clear. This will make the cannabis law very clear, and there shouldn't be any further confusion by a cannabis establishment. And hopefully that will prevent any establishment from taking that step as it has been done in the past, which of course caused workers to be underpaid for many months before it was resolved by the Department of Labor. So this will clarify the current law. It will make it absolutely clear to these establishments if they were to try and do this again in the future.
Thank you very much for that answer, Madam Chairman. And certainly I appreciate the clarity commentary. That's something that's very important to me. Maybe it wasn't clear to the establishment when they began paying their employees using this mechanism. But I have a more important question, which is you just said that those folks that worked at that establishment were underpaid. Were they paid less than the minimum wage?
Yes,
They were paid less than the minimum wage, including the tips that they had received in addition to their other regular wages?
my understanding in the testimony we heard is that they were paid a tipped minimum wage, which means they were underpaid because they are not eligible for the tip credit.
Understood, but you don't know whether or not they made less than the minimum wage.
I understand that the employer violated our statutes.
Understood. Okay. Well, I'm just trying to understand the circumstances here. You said that they were underpaid, and I don't know that that's a proper way to describe the situation if they were in fact paid the minimum wage. Is there an investigation? Is there something that we can look at to maybe understand a little bit better what actually transpired in that case?
I think that I've been very clear that they were underpaid because they did not receive the full minimum wage, which they were entitled to under our state statutes. So when somebody's not getting the wages that they are entitled to under state statutes, then they are, in my opinion, being underpaid. So I'll stand by that characterization.
Well, I appreciate your characterization, except I'm looking for objective facts. And if the minimum wage is a certain amount and these folks were paid a certain amount, and additionally received their tips and that amount exceeded the minimum wage, then I don't think that the State Department of Labor would consider them to be underpaid. And that's why I'm asking these questions. And I understand your desire to eliminate the tip credit scenario. And I can understand that if that doesn't already exist in current statute, it just seems to me that you're creating a new statute without a purpose if this has already been addressed in that one specific case, and there's already not a mechanism for that. So I'm trying to understand why this bill is before us, Madam Chairman. But I'll move on.
Let me just clarify, in case there was any confusion. There was a DOL investigation. They had been paid less than the full minimum wage. The DOL investigated and they were ordered to pay the full minimum wage, that the employer could not claim tips for those employees to meet the requirements of our tipped wage section that only applies to hotels and restaurants. So those are the facts. Any other comments or questions? Representative Weir.
Thank you, Madam Chair. I had, in addition to the comments that my colleagues have made or questions they've asked, I noticed, obviously saw the JFS language come out yesterday. It's significantly changed in terms of we went from a couple page original document that is now, has a bunch of language, but I guess the portion that it was 4 pages before. And that 4 pages, as I read it, has been boiled down to lines 114 through 120. In terms of the language relative to the cannabis establishment. Is there any other portion of this bill that came from the original bill into the JFS?
Lines 114 to 120 are the changes that will be incorporated into the current statute. That's in LCO number 6614, and I don't see any other changes to that statute.
Thank you. So the original bill that came through this committee that we discussed involved a lot of what my colleagues talked about was the minimum wage which again, the original bill talked a lot about labor, the Labor Department minimum wage. Under the new bill, that portion of talking about, that this industry is not eligible for tips, got moved into another part of the general statutes, as I read this, that talks a lot about labor organizations and labor peace agreement and unions and licensee and that sort of thing. What was the reason for moving it from where it was, when we were talking about the Labor Department, into this arena where we're talking about labor organization and labor peace agreement and such?
We believe that the clarification for cannabis establishments needs to be in the statutes that they most closely track, which is the cannabis statutes that we have. And then we're likely to look there to determine how they will set up their cannabis operations and show it more appropriately as there. In addition, as has been noted, the DOL statutes regarding minimum wage only allow a hotel or restaurant to apply for a tipped credit. And we did not want to make any confusions in that statute that there's some other establishment that might, in fact, be eligible for that. They are not. So very clearly putting this in the cannabis statutes makes it clear that this is a problem that it came to us that was specific to that industry.
Do we know, roughly speaking, what percentage of the cannabis establishments are represented by a union or labor organization?
No.
No. Okay. I guess the reason for asking that is why I just don't understand why so much focus on the rest of the bill talks all about labor unions and peace agreements and labor organizations, and then we put this in there, and I'm just trying to figure out, are we leaving potentially, does this only apply to a unionized cannabis establishment, or does this apply to any cannabis establishment?
I think it's clear that it applies to all cannabis establishments.
Okay, I'm just trying to understand why the rest of the bill talks about labor well, I made my point. I don't understand why it got moved into another part of the statutes that only talks about labor organizations and unions versus being left where it was in the Labor Department talking about minimum wage. Senator Sampson already talked about the fact that we know of one establishment that has been committing these violations. I think that, and I understand that was corrected through the Department of Labor. So I'll be a no today. I don't think I don't think we should be reacting to one incident where the Labor Department did their job, followed up on a complaint and handled it effectively. And to my understanding, the cannabis establishment is no longer displaying this behavior. They're paying their employees correctly. They were, I imagine, properly, they were properly admonished. If there were any fees or fines to be found in this state, I'm sure they paid them. And now they know better and won't do that again. I don't see the reason to have language that puts this in a bunch of language that has nothing to do. I think the original bill was more, the language seemed to be more appropriate for what we were trying to achieve. So I'll be a no today. Thank you.
Any other comments or questions? Seeing no hands, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded. Agenda item 1, House Bill 6842, an act concerning the minimum fair wage and persons employed at cannabis establishments. This is a motion to JFS to the floor, and the relevant LCO is 6614. Senator Kushner.
Yes.
Representative Sanchez.
Yes.
Senator Cabrera.
Yes.
Representative Wilson. Senator Sampson.
Sampson is no.
Representative Weir.
Nope.
Representative Hall. Representative Hughes.
Yes.
Senator Lesser. Representative Canino.
No.
Representative Gauthier.
Yes.
Representative Mastro Francesco.
No.
Representative Shake.
Yes.
Thank you, Madam Chair.
Thank you. We will, give me 1 second to arrange my papers. We're going to move now to item number 4 on the agenda. And that is House Bill number 5609, an act concerning retirement benefits and worker compensation benefits. And this is a JFS to the floor, LCO number 6592. Is there a motion? Second. It's been moved and seconded. This bill would require municipalities to, in their calculation of pensions, to count the employee's worker compensation, temporary total disability, and temporary partial disability benefits as wages if they are greater than the wages used to calculate the employee's final average salary under the pension system's terms. This requirement applies regardless of any other statute or special act, but does not impair or alter CBAs in effect before July 1, 2025. The S language here limits the use of workers' compensation benefits in pension calculations to instances where they are greater than the wages used to calculate the employee's final average salary for his or her pension. Any comments or questions? Representative Weir.
Thank you, Madam Chair. I just want to make sure I have the right. Yes, this is the JFS. We skipped number 2. We'll come back to that. Is that
I went to number 4
okay?
intentionally.
Okay. All right. I'm just rearranging my papers as well. Make sure
Because I want to move to number 4.
want to make sure I'm organized. Madam Chair, I have concerns with this bill. We heard testimony certainly from on this, and I just will go to the fact that a lot of times we in this committee, and I'll be happy to state that I believe in a union and an employee's right to collectively bargain without condition. I mean, that is, I think, the right that workers have. They have a right to organize. They have a right to collectively bargain. But in this case, as this bill, the way it sits before us, the way I interpret it is this, it's asking the legislature to get involved in that bargaining process and to take a side and to mandate that a city or town offer a certain type of benefit and take that ability away from the union and that municipality to bargain for those benefits and to negotiate and to discuss. We heard from some of the proponents of the bill as it stood before, again, it's changed from where it was when we heard testimony, but that was for 1 or 2 municipalities. And, I don't think that accurately reflects the entire state. We have, I hear all the time from my municipal leaders and from our boards of selectmen and town councils and town government that they don't want state government sending municipal mandates determining how they have to operate. And part of that is because it brings cost. A lot of times it sends an additional cost their way. We don't fund it here. And the ultimate people who bear that brunt are the taxpayers. I mean, eventually everybody in this room, if we're living in Connecticut, somehow the bills that come out of here as an unfunded municipal mandate are going to affect you. And so when I hear, hopefully proactively, usually proactively from my town leadership, they're urging me to support bills and concepts that allow them to negotiate freely, to determine what's best for the city or town. And this bill takes that ability to negotiate away. And so I think, all of us here are close with our town leadership. I know I hear from the 5 towns that I represent, whether it's the superintendent or a principal or the police chief, fire chief, town leaders, the boards of selectmen, you name it. If if it's involved in town government, they're watching and they're paying attention to what we're sending out of here. So I certainly don't want my hands on a piece of legislation that pushes, takes a decision-making ability away from those elected officials or appointed officials. And number two, adds a cost on top of it, potentially, so by passing this through, we're going to be sending a mandate that says you cannot collectively bargain with the unions, and management cannot negotiate. We're going to decide that for you up here, which certainly may not work for all towns. It may work for the one or two who came here. And I recognize that it's a problem in those municipalities, and I think that that is incumbent upon labor and management to work it out without bringing it to us to decide. I do not want to be doing the work of the negotiation on behalf of municipality, nor do I want to be negotiating on behalf of a union. And so for today, I will be no. Thank you.
Senator Sampson?
Thank you, Madam Chairman. Yeah, Representative Weir covered pretty much all the ground that I would also cover. I think it's important to point out that we already have, regulations in place. There's something called MIRA, which is the regulations that determine what are possible contract negotiations that can exist in municipal employment contracts between union labor and the towns themselves. And this bill effectively overrides that. It would essentially take that provision that is accounted for in MIRA regulations and put it into this statute. And as I've pointed out many, many times in the past, and Representative Weir just pointed out, this is a violation of the freedom of all the parties. The fact of the matter is, if you believe in collective bargaining, then you believe that the rights of the parties to freely negotiate should exist. And that should not be replaced by the actions of the Connecticut legislature, effectively completing that negotiation on behalf of one of the parties. It would be wrong if the items that are supposed to be negotiated were legislated in favor of the employer, the town in this case. And it's also wrong for the legislature to pass a law benefiting the union in this particular case. And as was pointed out, this effectively also becomes an unfunded mandate that is going to end up passing costs on to the people in the towns across Connecticut. And as a result, it drives up property taxes. And we have some of the highest property taxes in the entire country. And I just can't see us passing more legislation that is going to create more of an impact and a hardship for the people that we represent. And that's the fact, no matter where you live and whether that town's run by Republicans or Democrats. If this type of policy continues, where you have the state legislature negotiating on behalf of one side, in this case, the union labor, that's only going to drive up costs, create more unfunded mandates, and effectively make our state even less affordable. I can't support this based on that, Madam Chairman. I believe that the concept of collective bargaining should be protected. This bill flies in the face of that. This bill eliminates the right of both parties to bargain for this particular benefit. Thank you.
Representative Canino?
Thank you, Madam Chair, and my colleagues covered this pretty well, but I just wanted to add that, this bill would not be passed in a vacuum. There are two other bills before this committee, one handling PPDs, the other handling basically mandating municipalities to offer a pension. And if I'm a municipality in this state, what confidence do I have when I go to the negotiation table that the tenets of that negotiation aren't going to just immediately be violated the next year or in 3 years, 5 years by the state government through bills exactly like this? Like my colleagues have said, collective bargaining happens for a reason. It allows employers and employees to engage in consensual, I'm gonna sound like a broken record here, in consensual negotiations with each other to lay out the terms of their employment. And I think up here as a legislator, I might think that it is wrong for a municipality to count these benefits or awards, what have you, as wages and or not as wages, and to reduce a pension in that case. But it is not my decision. The municipalities are the ones who are engaging in the collective bargaining process in these situations. But if I'm a municipality in this situation where this law is passed, how is it fair to me? If a few years down the line, the state that ends up declaring that something in our contract that we negotiated between each other is abhorrent, well, then I probably negotiated something away as the municipality for that, right? The union isn't just going to give that up without getting something in return. So we're not requiring the union to give up what they got in that negotiation, just the municipality. And all of these laws that we're considering go in that direction. Not a single one of them benefits the municipality. They all go in favor of labor. And that just doesn't seem fair to our municipalities who are already under such a burden right now from every single unfunded mandate that we put onto them. And this is just another one of those. The burden always falls on the backs of the municipalities in these cases. And for those reasons, and for the reasons of wanting to protect the collective bargaining process from state interference, I'm going to be a no as well today.
I see no other hands, but I would like to make a couple of comments on this. We heard some very compelling testimony on this bill, and I think that it was, for me, shocking that a firefighter could work for many years and in the final years get hurt on the job and have their pension calculated as a zero for the years that they were on workers' comp. That was shocking to me. It shouldn't happen. And we need to do something about it. And that's why this bill is here. There are lots of statutes that deal with labor relations beyond just the right to organize and collectively bargain. The minimum wage statutes, for instance, say you can't pay less than the minimum, the fair minimum wage in Connecticut. We passed a bill about safe staffing ratios in hospitals out of public health. There are bills in lots of different committees that address the employee-employer relationships where we feel it necessary to intervene. And this is an area where I think our committee feels it very essential to intervene. We know that there are terrible problems in recruiting and retaining our first responders. And one of the deterrents could potentially be the fact that you could have your years of service wiped out because you got hurt on the job at the end of your service. And it feels unfortunately, we're not able to address that firefighter that we heard testify. We're not able to address that situation. This will not go into effect or impact current contracts, but we shouldn't allow it to continue as a practice by any municipality. And as a taxpayer, I think we all, as taxpayers, need to recognize our obligation to the first responders in our communities that risk their lives to protect our property and our lives, and that none of them should work for as many years as these guys did and have a zero calculated in their pension. So I feel very, proud of the committee member who brought this forward in her first term. We appreciate her efforts here. We appreciate all the efforts of our firefighters and our law enforcement to keep us safe. And I think this bill is one way to demonstrate more than just our thanks and our signs sometimes that we show to them, but to actually do something that will correct something that should never have happened. So I am proud of our committee for taking up this action and look forward to moving this bill from committee to the chambers for final passage, and I hope it will be signed into law by our governor. So with that, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 4, House Bill 5609, an act concerning retirement benefits and workers' compensation benefits. This is a motion to JFS to the floor, and the relevant LCO is 6592. Senator Kushner.
Yes.
Representative Sanchez.
Yes.
Senator Cabrera.
Yes.
Representative Wilson. Senator Sampson.
Sampson is no.
Representative Weir.
Nope.
Representative Hall. Representative Hughes.
Yes.
Senator Lesser. Representative Canino.
No.
Representative Gothier,
Yes.
Representative Mastro Francesco, Representative Shake.
Yes.
Thank you, Madam Chair.
Thank you. And I neglected to mention on item number 1, but we did not take the tally on that, and we will not take a tally. Votes will be held open. We know that many of our committee members are in other meetings, and therefore will hold votes open until time appointed at the end of our agenda. Moving to item number 5 on the agenda, this is House Bill number 6517, an act concerning disclosures of salary ranges on public and internal job postings, and it's a JF to the floor.
Third.
It's been moved and seconded. This bill requires employers, including states and municipalities, to give job applicants and employees the wage range for their position upon request, and prohibits employers from taking certain steps to limit their employees' ability to share information about their wages. The bill expands the wage disclosure law to require an employer to include a position's wage or wage range and a general description of the position's benefits in its public and internal job advertisements. Any questions? Representative Canino.
Thank you, Madam Chair. So the title of this bill is an act concerning disclosures of salary ranges on public and internal job postings. But does it also require the disclosure of benefits as well?
Yes, it does.
And is that all benefits? So healthcare, 401k, maybe some mileage reimbursements? Is it the full package of benefits or only certain benefits?
It's defined in line 4 as benefits means health insurance benefits, retirement benefits, fringe benefits, paid leave, and any other compensation to be offered with the position.
Thank you. And the reason I ask is because, this topic of salary disclosure, it's not just limited to that. It's limited to these benefits. And we are now requiring our employers in this state to publicly post the terms of employment that they offer, which might sound like a very noble thing to do. Who wouldn't want more transparency in these situations? But you have to realize that the negotiation between an employer and an employee for the terms of their employment, there's benefits to withholding some of that information on either side. An employee might want to withhold what they have been paid in the past, and the employer might want to withhold what they are willing to pay. That's just one reason that an employer might not want to disclose a salary range. Another is to protect their competitive advantage. If they don't want their competitors to know what they're paying their employees, I think that's perfectly reasonable, and especially in terms of the benefits package. That way, it protects them from having their competitors be able to go in and either and have a clear-cut idea of what their competitor is providing, and then go a step further than that. Preventing the disclosure of this also might prevent discord within their own employees if it causes chaos in the workplace when employees all of a sudden learn what new prospective employees are being paid. It is definitely within an employer's right to want to protect that. This also protects their bargaining capacity with the prospective employee. They have a right to withhold what they're willing to pay until negotiation. And just like the prospective employee has the right to withhold what they are willing to work for. But you might have a situation where an employer wants a little bit more flexibility. Let's say they're offering a job for $60,000 a year. They have an employee who comes in, they're bright, they're energetic. They seem like they'd be a great employee, but they don't have a few of the hard skills that are required for full compensation for that job. Well, the employer might want to grab them still and have them employed under them and train them in those hard skills for, let's say, a year. And so they might say, listen, we want to pay you $50,000 for a year. We'll trade you for that year. And then at the end of that year, once you've proved your adequacy, we'll get you back up to $60,000. This removes their flexibility to do that. Because if I'm not mistaken, it holds them to account. If they go any lower than what is posted on that job application, they could be fined between $1,000 and $10,000. That is absurd. When we are trying to bring more employees to the state of Connecticut, we're trying to fill more jobs. Right now, we have more job openings than there are people looking for jobs. And now we want to reduce the flexibility that an employer has to offer conditions to that employment. It just does not seem like the path that we should be taking. Madam Chair, is it already state law that you have to, that an employer has to provide the information of their proposed salary range when requested by an employer?
There is existing,
Sorry, employee, I misspoke.
I understood what you meant. There is existing law regarding this, but we are changing that law through this legislation.
Thank you. This bill, in the testimony from the proponents on this bill, it was stated that this is intended to decrease the gender wage gap. That seems like a non-argument to me. That seems like something that is so unrelated to what we are doing here, because it is my understanding that women are not any less capable in asking their employer for that salary range when they are in an interview. This really does nothing but provide employers to show their hand in this negotiation, in this consensual negotiation between employers and employees, and yeah, requires them to tip their hand and show exactly what their bargaining position is while requiring no such concession from the employee. Another scenario, what if the company's fiscal health changes while the posting is up there? So let's say they have a salary range for a position that they're posting that's between $50,000 and $60,000, and the company starts to struggle within the month that the position is up there. If they wanted to lower that range, they would be found in violation of that statute. Like, let's say they were in contract negotiations with an individual, and during those negotiations, it became clear that they weren't going to be able to pay that person that amount. Well, they would have no flexibility to offer them that lower range without facing a pretty stiff penalty. And again, $10,000 per employee. So I'm going to sound like a broken record again, but here again, we have a situation where we are violating the consensual contracts between consenting individuals. And we already have a law in the books where people can freely request this information, and the employer is required to provide this information. I think that in this state, we need a healthy dose of mind your own business, of this is the onus of the employer and the employee to have full transparency with each other. And if one person feels that like they're not being dealt with honestly and that there's not enough transparency, then they are free to either seek different candidates or to seek different employment. So for those reasons today, I will be a no on this bill.
Thank you, Representative Canino. I do want to make one thing clear on the record, that some of the comments you made implied that the employer would be required to pay within that salary range, and there's no requirement such as that. So at any time, the employer can pay less than what their salary range is. The obligation under the statute is to make that disclosure of what the range is. That still gives them the freedom to hire at a lower rate. That's for clarification. Representative Hughes.
Thank you, Madam Chair. I understand the confusion because if you haven't been looking for a job, maybe you don't understand that posting is not a negotiation. A posting by the employer is a transparency of a range of seeking the qualified applicant position. You can certainly enter into a negotiation about the actual terms, but it's largely to stop wasting everyone's time. If we're going through the application process and we have no idea until you get to the third interview what the range is, a lot of applicants don't want to have their time wasted like that. This has been a huge issue that we have moved forward in this legislature to close the gender wage gap, because largely women were underpaid because there wasn't transparency about what their male counterparts would be offered for the same position. So this transparency is really important to closing the gender wage gap, and the lack of transparency of postings has largely been a perpetrator of why we still are only making 81 cents per dollar of our male counterparts. But I am gratified to hear that members of this committee do believe in equal pay for equal work. So I'm hoping that everyone can support this, and understanding that posting a a range is not an interference in a negotiation and a private contract. A posting is not a contract. Thank you, Madam Chair.
Representative Canino.
Thank you for indulging me for the second time. I just want to address some of those points. So in terms of wasting somebody's time, an individual is already free to, at the second that they enter into an interview with that employer, to ask them what the price that they're willing to pay them is, what the wage they're willing to pay that employee is. So you don't have to wait until the third interview to get that information. You have the right to ask it immediately, and they are required to provide that to you already. All this does is it does weaken the ability for an employer to negotiate, because it not only requires them to tip their hand without even being asked, automatically by law, published for the world to see, but it also reduces their ability to compete, because it provides their competitors with a really detailed description of all of the employment benefits that they offer, and allows their employers to compete with information that they wouldn't have otherwise had and that they are not deserving of. And so I really don't agree that this holds the employer harmless in terms of a negotiation standpoint. We already have a mechanism where people can get this information very transparently. And by saying that this does anything to impact the gender wage gap, I fear falls prey to the soft bigotry of low expectations, saying that a woman is in any capacity less able to ask an employer what that salary range would be. They already have the ability to do that just as much as men do, and making this change, I do not see any way that makes a change in that realm. So thank you for indulging me for the second time. Still a no on this bill.
Sen-
Thank you very much, Madam Chairman. I think Representative Canino did a great job covering this bill and some of the concerns with it. And I had to leave the room, unfortunately, for a moment. I'm in 2 committee meetings at the same time with extensive agendas. So forgive me for bouncing in and out. But I wanted to just ask a couple of questions about this bill, particularly in lines 17 through 22. There are some changes being made to the current statute. I noticed that there is this change from the word comparable positions to equivalent positions. And I'm just curious what that means and what impact that change will have. Thank you.
I think equivalent is a descriptor that makes clear that the job has to be equivalent. And we could get a dictionary out and get that clarified, if that would be helpful.
Well, thank you very much, Madam Chairman, except I don't know that a dictionary will solve the problem. Is it your opinion that there are equivalent jobs?
Yes.
And how does that work? I mean, are all employees the same with their ability to contribute a certain amount of work in a certain amount of time, et cetera?
I think there are jobs that are equivalent. I didn't speak to the employees being equivalent.
Understood. But if we're trying to create some standardization for how much a salary should be, and you're doing it based on an equivalent position in this particular case, then doesn't that imply that somehow the employer should be paying for the same amount of production?
This bill does not require the employer to pay an equivalent salary. This bill requires transparency and disclosure.
Transparency and disclosure of what exactly?
Of a salary range and of benefits that would accompany that salary.
Thank you very much for that answer, Madam Chairman. So if it's asking for transparency and accountability of a salary range, that is creating an expectation that the employer is going to be paying a certain amount for a certain equivalent position. Am I wrong about that?
Before you walked back in, I did clarify, because I think Representative Canino raised a question of whether or not there was a requirement because of this bill to pay a certain salary, and that is not required by this bill. And whether or not there's an expectation is not covered in this bill.
Well, thank you for that. I appreciate that. So then I'm confused on how this is going to address the problem that you suggested when I was walking in about the gender pay gap. How does that solve that problem, if that problem exists?
Well, I wasn't speaking when you entered, but I was raised by a committee member that that would help address gender related pay discrepancies or pay differences that we know exist. And it is believed that by knowing what the salary is going in, that a person would be less likely to undervalue their worth, and they might be more likely to negotiate for pay within that salary range. But there is nothing within this statute currently, or as it's been proposed, to require an employer to pay a certain amount of money or provide a certain level of benefits.
Thank you very much, Madam Chairman. I think if we could play back the conversation we just had, I think people would be shaking their heads like I am internally right now. I'm like, on one hand, you're telling me that it does not require anyone to pay a certain amount, but you're also saying that because the person knows their salary going in, and these are your words, that is going to help eliminate the gender pay gap that you know exists. So I don't understand it. But I don't even know how to ask a question now because I'm so baffled by your responses because it seems like you're suggesting one thing on one hand, but then when I ask you to confirm that is in fact the case, you are quick to tell me that there's no requirement in the bill for an employer to pay a certain amount. But there is in fact a requirement for the employer to suggest how much they would pay for a job. Is that correct at least?
The requirement of the bill is that the employer post the salary range.
Understood. How can an employer know a salary range if there is no understanding of the range of the quality or capabilities of their prospective employees?
There has been a bill, there's already statutory requirement to post salary ranges. So we've already, I think, addressed that. This bill changes in a number of ways, but particularly by telling them, requiring the employer to also post the benefits that would accompany that particular job.
Well, I appreciate the answer to the question, although it didn't address my question. And I'm aware that this is a current law. You and I debated it at length in the Senate a number of years ago. And
Not true.
I remember voting no on it. And I remain still unsatisfied that this performs any benefit in our society. In fact, I think it is harmful to employers and employees, as are most of the actions taken by this committee. Because they interfere again in the freedom of the people that are involved to figure these things out for themselves. Every time you inject the state government into this free agreement between consenting parties and require new conditions to be added, you're basically eliminating some amount of opportunities. I don't know if it's small or a large number of opportunities, but you're eliminating some. And that certainly cannot benefit the parties or our society as a result. I'm still looking for the answer for what's the difference between comparable and equivalent. And the reason why this is very important to me is because you said that this is current law. We're just adding the requirement that they have to share benefits, but it's more than that. We're also changing that phrase. And to me, that can make a big difference. I mean, an employer is going to be looking at this bill when it becomes law, and they're going to have to navigate this to make sure that they're compliant for fear that they might be sued or held to account by the Department of Labor. And I don't want them guessing what that means. And for me, I don't really understand the difference between comparable and equivalent for this bill. And that's why I think it's important for the committee to make it abundantly clear exactly why that change is being made.
Senator Sampson, you quoted me as saying that this bill was just about benefits, and that's not what I said. I said, among other things, about benefits. And there are other changes in here, which I have acknowledged in this debate and the discussion in this committee today. So just want to clarify that those comments by you are not accurate in terms of what I said. I do believe I've answered your question about equivalency. And if you have any other requirements, you obviously are free to go to attorneys that you may know and ask them what they intend, and you're certainly free to vote whatever way you want on this bill, but I've answered it to my best ability today.
I appreciate the answer, Madam Chairman, and certainly I did not intend to mistake your words. I thought I was quoting you accurately, and I apologize if I was implied that you said something that you didn't. But the fact of the matter is, we don't have an answer for comparable and equivalent. And is it your opinion that every employer in the state of Connecticut that will be subject to this new law, if it's passed, that they should have to go to their attorney to find out what this definition means?
No, I think most employers will figure it out.
And what about the ones that don't figure it out? What about them?
If they can't figure out the statute, I'm sure they already have attorneys that are advising them.
Thank you very much, Madam Chairman. Your answers are very much on point, and I don't disagree that you've answered them. However, I don't think that the answers are satisfactory from the employer standpoint, and that there will be a lot of questions. And I'm concerned that people are going to get caught up in this legislation unnecessarily and maybe penalized as a result. There's no such thing as an equivalent position. That's the first and foremost point that I'm going to make about this language. There's zero definition of that. The only way you can have an equivalent position possibly is if you had two robots doing the same job. Maybe they would perform the same amount of work at the same level of ability and speed based on their qualifications and experience, because they're identical machines. But human beings are not machines, and every one of them is different from another. Another thing that seems to escape this committee, which insists on putting people into categories constantly, the first categories being employer and employee. This bill, which calls positions equivalent, doesn't apply in the real world, because there are not equivalent positions. You could hire 10 or 100 different people for the same job, and they're all going to do it differently. Each one of them is going to stand out in different ways. Some of them are going to be far more capable from a customer service perspective, while others might be much more capable from a standpoint of getting more quantity of work completed in a certain amount of time. Some people are going to be quicker learners than others. Some people are going to come with vastly more experience than others. And the fact of the matter is, you cannot be suggesting that those people should be compensated the same, because they're not the same. And an employer realizes that, and that's why they don't typically produce, narrow salary ranges to suggest what a job is going to be paid. And the fact of the matter is, many employers ultimately don't even understand 100% the job they're going to require of that employee until they actually have the employee, because they're going to play on the strengths and capabilities of that person to create the job for them that benefits the company the most. This is not a cookie cutter world, and trying to make it into one is only creating impediments for people who want to produce and succeed. And that's employees. Employees will not benefit from this bill. Women supposedly getting paid more because of the so-called gender gap. That's not going to result from this either. What's going to happen is you're going to create a mechanism to put more pressure on employers to conform and comply with, frankly, these irrelevant requirements that don't really apply in the business world. This bill deserves a long debate, and but we'll save that for a future date. And I look forward to the day where I serve in a majority. I can and am in a position to repeal some of these things and help restore freedom in the workplace between employers and employees. Thank you.
Representative Gothier.
Thank you, Madam Chair. The word equivalent to me seems pretty straightforward in that it applies to the position. So the way I think about it, and feel free to correct me if I'm misunderstanding, two equivalent positions. The equivalency in the position would be each employee has to deliver 50 packages in a day. Now, I might, as an individual, might be able to deliver 100 packages in the same time frame that the person next to me can deliver 50, but the equivalency in the position is that you have to deliver 50 packages. That's what it seems to be to me, and seems to make a lot of sense that if the job requires the same task to be completed in the same amount of time, then you have the same salary range for those positions. So, thank you.
Any other comments? Representative Weir.
Thank you, Madam Chair, and I thank you to the representative for, for giving that example. I just think this is, I guess I'll respond to Representative Gauthier if I may, just in terms of a difference, before I go on with some of my questions, just because it's fresh in my head. I think it's bigger than, a little bit, considerably bigger than that, in terms of there may be shift differentials, there may be many other variables than the packages. So I get that the package could be one, package delivery could be one way to measure output or an employee's requirements of X number of packages, could be reporting to a different location, could be a different shift. So there's a lot, this is very multidimensional. And I really think that the reason we're bringing up that particular, honing in on that language is because it's a change, right? The existing language was comparable, which quick Google search, is similar. And if you go to equivalent, one of the words that is used to describe equivalent is equal. And we've made that we could have had a 4-hour long debate just on changing one word in terms of what that does with the downstream results to the employer and employee relationship. So I say this not to be argumentative and difficult, but that one word, you could have the whole bill be changed turned on its ear without making the other changes that we're talking about here. And having been an employer, Madam Chair, you used the term employers will figure it out. And that I've heard that before in here. I've made that statement that we pass things out of here without input from employers in this conversation. And we assume that they'll figure it out. And very few of us here may have that perspective to say, they're not always going to figure it out. And when they don't figure it out, you have two parties who, the employee and the employer, who we've pitted them against each other from actions that this committee has taken, never mind the entire legislature. We assume it's an adversarial relationship, and it doesn't have to be that way. But when we start putting them in this box and tightening the rules of engagement between the two parties, we really create an issue for an employer who may not be an attorney or have any, may not have a background in law, and certainly the employee may not either. And now the only way that I see that this is going to be sorted out is with the attorney. So now the employer has to hire a labor attorney, or the employee has to hire a labor attorney, because the language isn't crystal clear coming out of here. And so I think we're dwelling to some degree on that word, the change in word, because you've gone from similar to equal. And then, I think we need to have a good reason. And there should be, in my opinion, I expect that there's a clear definite reason why that change was made. And I don't want to have to go to the dictionary or consult an attorney. I think that if we're making a change to legal language that people are going to be held account to, I expect the definition. I don't think that's unreasonable to say, here's why we made the change and here's the effects that it's going to have downstream. And maybe I would agree. But we don't have that. And I don't think that should be defensive to have to explain. That's materially changing existing law just with that one word. So wanted to make that comparison. I do want to ask a few technical questions and then make a few statements, Madam Chair, if I may.
Please proceed.
So lines 4 through 6 talk about the benefits. I know I'm not going to exhaust this take this to exhaustion. Representative Canino spoke about this, and Madam Chair, you did address, but I do want to point out that, there are many benefits that go into an employment package, and some of it is wages and salaries. Could be travel expenses, training. In fact, we did tour Amazon week and change ago, the facility to see how they operate toward their warehouse facility. And, it's publicly, I didn't realize this until walking in the door. This is not proprietary information, but part of their wages and benefits, they include free tuition for any free college tuition. They've got an agreement with the state college system. Any employee, just about day one, I think maybe within 90 days, they can have their tuition prepaid on behalf of Amazon, as that employee could go to UConn, if they, Central Connecticut, could be our community colleges. That's paid for, and that's a benefit. That's a benefit that goes on top of the wages. But that may not be what that employee is looking for coming in the door. But there are many employers who have similar type arrangements. Paid leave for a spouse, that was another benefit that was offered by Amazon, where the spouse of the employee may not have paid leave through their employer. Amazon picks that up in many circumstances. So this is not an advertisement for Amazon, but because it's fresh in my mind, those are types of things that may not be listed on a wage offering, because the possibilities are endless. I've had employees who didn't have transportation, and so offered them a company car, and that was as important as getting paid time off or some other benefits. And, I didn't, that person coming in the door with a range that we're trying to tighten down here, and we've gone from comparable to equivalent. We've tightened that box down in terms of now as an employer, what do I have to put on there? I might be able to give you a car if you need one. I mean, so sometimes leaving it vague only to the stuff that's, I guess we're deciding at this level what's important and what must be put in a job offering. And so by saying that benefits, and any other compensation, I mean, that could be endless. It could be something that the employer didn't even think about, but the employee needed and may mention it at that job interview. And I've had that happen firsthand. It may be I need to leave every day at 2 o'clock because my wife works second shift and I need to be home to take the kids, but I'll come in at 5 or 6 a.m. And, maybe that's not an exchange of a monetary compensation, but it may be that flexibility, flex time that employees are looking for that doesn't have a dollar sign attached to it. Because if the spouse has to work second shift and the person coming in for this job has a flexibility in their schedule, now you can have 2 people in the household working without the need to pick up childcare as an additional expense. So I just want to give you those examples because I've seen those examples and probably 10 times that I'm not even remembering where as an employer, I've needed something that the employee didn't think maybe they were capable of offering, and turns out they had that skill after all. Or they came in with a skill set that we weren't expecting, and the job position changed based on this person's experience, work history, life experience. So when we talk about benefits, we really have that the sky's the limit. And, I can see this list of benefits being extremely long on a posting, or some other disclaimer that says, use your imagination. I'm really not sure, because in the past, this was always left up to the employer and the employer to work it out. I don't want to make law coming out of here that they have to figure out. Madam Chair, on page 2, line 18 talks about what we've talked about. It removes anticipates relying on when setting wages, and it changed that to sets in good faith. What's the expectation of, why was the reason for that change? I don't think that question's been asked today.
It has not been asked, and I believe that changing it from anticipating relying on when setting wages, that is probably from a legal point of view, not as clear as saying sets in good faith. Because I believe we're trying to clarify this for employers. And I think that's a more common phraseology that one would expect to see in statute.
Thank you for that answer. In this case, if, who would be the person to determine, or how is good faith determined? And I guess who decides, who makes that, determination of, in good faith?
I think that that would, if there was a challenge to whether or not the employer had properly adhered to the statute, then that would be, I would assume eventually it would be investigated and that determination would be made if that part of the statute was being challenged by an individual who had applied for a job.
Thank you. So would that be investigated by the Department of Labor, or is that, if it goes to civil court, or, you only because you mentioned, I heard you say if it's investigated, so who would be the person or entity investigating a claim that the employer didn't, or not even employer, could be a prospective employer, didn't act in good faith?
Looking at the statute, and this is not an area that we changed, but it does refer to, in lines 81, it does refer an action to redress a violation of subsection B would be maintained in any court of competent jurisdiction.
Okay, so
And it does designate the changes that we did make there, obviously, are underlined in terms of laying out the penalties.
thank you for that. So it doesn't, at that stage of the game, it does not involve the Department of Labor. This means that the employee has to make a complaint, as I read this, of any of those violations, lines 23 and on, and would have to take legal action against the employer. Okay, thank you for that clarification. On 50, paragraphs where it's 53 through line 60, I do have a concern. I don't think this is a question. I'll just point out a concern that in this case, that's for a prospective employee, as I'm understanding this, where it talks about general description of benefits to be offered. I pointed out earlier that I think that list of benefits, generally speaking, could be extremely long. If you wanted to offer all the benefits that could potentially be added in addition to just straight wages. And again, person coming in the door may not even know what they're looking for, and neither may the employer. The combination of wages and benefits equals that total compensation. In some cases, it's taxable. You got to report it to the IRS as the employee. Maybe a wage or shift differential may not be, but if you're getting a company car, that would have to be. So that could all be included in the total package. But I'm concerned with that paragraph, that seems to deal with prospective employees. And by asking the employer to tighten that down, we could be offering proprietary information to a competitor. I want an employee coming in the door. I don't want somebody who's an engineer applying for something that they have no experience in. So you want to make the job description, in my history, specific enough so that you have an appropriate person applying for the job, but maybe not so tight that I'm telling my competitor down the street, here's exactly what we offer, here's what we pay. And, so some of that information, leaving it somewhat vague, allows for a discussion when somebody comes through the door. That can all be discussed during the interview process, but putting that out there for all to see, I don't see that as a good practice. I think we're putting employers at a disadvantage with their competitors, not necessarily with the employees. That's I want the employees to get as much as they can, provide as much value as they can to the employer, help grow the business, help enrich themselves and learn and grow. That's not what I'm getting at. This, I think, gives a unintended, maybe, could be a hindrance and hurt competition. I understand the part about any discussion of the compensation. So now here's a question. Is lines 66 through 71? Can you confirm? I seen that appears to be an existing employee asking for an internal job posting, whereas the example I gave before was an external posting. Do lines 66 through 71, does that deal with an existing employee? Or is that for existing employees? It seems to be that that's an internal job posting.
Thank you. I think it specifically says in line 66, internal or public job advertisement. I'm not sure why you're inferring this would only be internal.
I missed the public, excuse
Okay.
me.
Yeah, I'm sorry. I thought maybe I misunderstood you.
No, just. Okay. I'll move on from that. Line 72 talks about refusing, the employer shall be in violation, without going back to the language, but in violation or whatever. Annually providing an employee with the current wage or wage range. Have we determined that that has to be on an on a calendar year, or is that based on a anniversary, or who determines? How is that annual determination made?
I don't believe we proposed a specific excuse me. I'm sorry. Back on the record. I don't believe it's defined here annually, whether it's from the employee's first date of hire or whether it's on a calendar basis.
Okay, so just for the intent of the bill, is it safe to say a 365 day period, and that can be determined by the employer, whether it's a calendar year or a employee anniversary date?
I think I responded appropriately by saying it's not defined here. Court of law might decide how it should be interpreted.
Thank you.
I will say that I'm not sure we want to define it here, but you could choose. If you feel otherwise, you could certainly speak to us about it and we would give that due consideration. I believe this will pass out of the committee today. And if that was something that was important to you, we could have a continued conversation about it.
Yeah, I think to that extent, language that states it's, the employer can determine, I think that it doesn't say, so it's vague, I get it, but I think we could make a clarification by leaving it up to the discretion of the employer perhaps to determine that. So on line 75 or lines 78, line 75 through 78, I should say, talks about retaliation and discrimination. And my concern here is if you have an employee who complains about a job, complains about how a job is posted, and what this doesn't address, and I think my point to make here is that we're trying to tighten this down too much, is you could have an employee who commits an unrelated violation in the course of his or her work, is disciplined, and now makes a claim that that was tied back to complaining about a job posting. I'm just going to make the comment that I think we're tightening this down too much. I think we're opening, I think we're really inviting discourse between employees and employers through this language, by telling an employee that, they've been discriminated against if they complain about, it's not what I'm trying to say here, but the bottom line is if they make a complaint about how this is posted and they're disciplined on another matter, I think we've created a really confusing situation here. Next question's on lines 84 through 86, Madam Chair. Who are the damages paid to? Is that, do the damages go to the employee? Talking about a statute. The employer is liable, but who are the damages paid to? Is that go to the state or is that to the employee?
I'm assuming it would go to the employee, but I would want to check if you want to give me a minute. I have confirmed that it would go to the employee.
Thank you. The employer would receive it. Thank you. In lines 89 through 90, Madam Chair, who may bring an action? It says there's 2 years, an action may be brought. Is that also by the employee or is that, who can bring that action?
An employee.
Thank you. And then lastly, at the last section, just want to make sure I understand the last section. It talks about these will apply if the duties, may I read this word for word, just so I'm not paraphrasing what's here? The provisions of this section shall apply to any position in which the duties for such position will be performed within the state or in which the duties for such position will be performed outside of the state, but requires the employee performing such duties to report to a supervisor, office, or other work site located within the state. And so I understand the reporting to the office or work site located within the state. An employee lives in Massachusetts, has an office in Connecticut, is located within the state. Does this cover an employee perhaps who maybe works for a large aerospace firm or, you know, where there's multiple locations around the country, say, you know, Ohio or North Carolina? The employee lives in Ohio, is telecommuting. That person's supervisor works in Connecticut. Does the employee have to physically report to Connecticut for this to apply, or does this apply if there's telework, but the supervisor's in Connecticut?
I believe it would apply in the latter case where they're reporting to a supervisor, office, or work site that's located within our state. So it could be someone who's working telework, but they're being, their work is being controlled by an office or supervisor in the state.
Okay, I think I covered just about everything. I appreciate the ability to a little back and forth with our colleagues. Appreciate the comments made by my colleagues here and also the other side of the aisle. Yeah, I really think I know that we have created something here that's going to be confusing. You know, sending language out of here that employers have to figure out really is a message to employers in Connecticut that, you know, we don't value the services you're offering. We don't believe that the employees and the employers can negotiate between themselves. That we don't trust that process is fair and impartial, and that both sides benefit in that negotiation. And the fact that we're going to have attorneys who are going to have to be involved to figure out this legislation is a real shame. So thank you for indulging me. I'll be a no today.
Any other comments or questions? Seeing none, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 5, House Bill 6517, an act concerning retirement benefits and an act concerning disclosure of salary ranges on public and internal job postings. This is a motion to JF to the floor. Senator Kushner,
Yes.
Representative Sanchez.
Yes.
Senator Cabrera, Representative Wilson, Senator Sampson,
Sorry, Sampson is no.
Representative Weir,
Nope.
Representative Hall, Representative Hughes.
Yes.
Senator Lesser, Representative Canino,
No.
Representative Gothier, Representative Mastro Francesco, Representative Shake.
Yes.
Thank you, Madam Chair.
Thank you, and we will be holding votes open. The next item on the agenda is item number 6, House Bill number 7195, an act concerning unemployment benefits for paraeducators. And this is a JFS to the floor, LCO number 6593.
Second.
It's been moved and seconded. This bill would require unemployment benefits for paraeducators who are not working during the summer. The S language removes a provision that would have created a rebuttable presumption that a paraeducator did not have reasonable assurance of returning if his or her school district did not submit the required information to DOL. Any comments or questions? Representative Canino.
Thank you, Madam Chair. So we heard a lot of testimony on this bill, and some really interesting stories from paraeducators, from individuals representing paraeducators about the struggles that they deal with, not only during the summer, but during their employment. One of my good friends is a paraeducator and routinely acknowledges to me the difficulties that he faces. It's one of the lower paid jobs in the school system with a very high workload. However, there were concerns raised here by the Department of Labor that were a little concerning for me, so I just wanted to clarify them very quickly. So correct me if I'm wrong, but if an individual has a reasonable assurance that they will return to work, they are not entitled to unemployment?
Hold on one second. I believe this would provide unemployment to someone, even if they have a reasonable assurance to return to work, if they're not working during the summer in another employment. Some paraeducators do work over the summer, sometimes for the school district and sometimes for other employment. But this would provide unemployment in the instance where a paraeducator is not working during the summer.
Thank you for that answer. Yes, because the Department of Labor raised some concerns that this would place the state of Connecticut out of conformity with federal law, because only the Unemployment Compensation Agency can determine if one has reasonable assurance. I was just wondering if that was given any thought in the drafting of this bill, and if this in fact does put us out of concert with federal law.
Yeah, we're well aware that it changes conditions for workers in the state of Connecticut to receive unemployment, which has been done in other states and certainly can be done here. I remember when the feds changed their approach to unemployment benefits and no longer provided it to workers who had a reasonable assurance of return to work. Unfortunately, many of those workers were low-wage workers and anticipated unemployment in the summer to help them get through. And when that was removed in, I believe it was the late 1970s, it might have been early 80s, by the federal law, it was really damaging to employees, some of whom I have represented. And so I think it's taken us a long time to address this issue for paraeducators. Like I said, a lot of them do continue to work during the summer or find other appropriate work during the summer. But for those that cannot work during the summer, this is really important to address the low wage situation that they're in. And so that's why we are very consciously making this change to address that need. The fact that it is different than what is provided under federal law is understood by us. We did hear some of the concerns of DOL and wanted us to remove that language about the rebuttable presumption, which would have put the burden on DOL and the employer to establish whether they had a reasonable expectation to return to work. We've removed that. So I think that addressed some of the concerns that DOL raised.
Thank you for that response. And yes, this also requires new reporting. It places new reporting requirements on individual boards of education, on individual schools as well. While the second issue in DOL's testimony was addressed by that JFS language, it still seems that like you said, putting us out of concert with federal law is still the case here. I look forward to the rest of the discussion on this bill. I'm not sure how I'm going to vote on this one yet, but I look forward to any further comments from my colleagues. So thank you very much.
Representative Weir.
Thank you, Madam Chair. I don't have a ton on this bill. Not a ton to say that Representative Canino didn't cover already. But I will say, and I think I think there's not one of us in the entire legislature, special ed has been a hot topic in terms of funding special education. And as equally important, in addition to our state budget, is our town and city budgets that that are constantly strapped. Between our electric bills and the municipal bills that we pay, we have one of the highest costs of living in the entire United States. And that's not lost on me, that every time we're considering a bill coming out of not just this committee, but our other committees and coming out of off the floor and being passed into law, I'll speak for myself in not wanting to pass additional costs onto my municipality or my fellow taxpayers without good reason. And if at all, that reason's got to be a very, very high standard. So in moving this along, we are going to affect our school budget. Some towns, they're built into the town budget. In some cases, the school budget is separate. But one way or the other, that cost is going to be passed on to the taxpayer. And by passing this bill, we add additional costs for the school system and the employer, in such that the school system pays into this unemployment compensation fund. And with these employees now being eligible potentially to collect unemployment insurance for a job that is clearly not seasonal, but that clearly has a period of time when there is no work, that people know it going in. I have friends of the family who are paraeducators. I have acquaintances who are paraeducators. I know it's not an easy job. I acknowledge it is one of the lower paying jobs in the school system, if not the lowest. But these are all things that can be negotiated at that local level. And I think we're coming back to a common theme here, that we pass a bill out of this committee that tells and directs a school system how they're going to have to compensate their employees, including making access to unemployment insurance. On top of which, we've added costs, we've added a reporting burden to some extent on the school system by saying that 10 days before the school year ends, they're required to submit a list and a census to DOL. And then we've also mandated that DOL now has to do something with this list in terms of getting this information processed and these people into the system. So we've created extra work for everybody around, and extra cost if we pass this bill. So I'll be a no today. I cannot support another municipal mandate when we've got my friends and neighbors who are unable to, seniors, unable to pay their bills, crying for property tax relief in some cases, utility bill relief. And while I acknowledge this is a lower paid part of our workforce in our school system, I think that's contingent upon the school system and the municipality individually to determine how to compensate those individuals, not this legislature. So I'll be a no today. Thank you.
Representative Wilson.
Thank you, Madam Chair. So I will say, for the context, I know this area probably the best on this committee, having actually been a paraeducator myself. So I understand there are not every single school district where paraeducators can negotiate the terms of what their employment looks like for the entire school year. And so it's the understanding that paraeducators, it's not just that special ed group. It could be individuals outside of just that group. It's based off of the way that the term is used within a school district. And so, there's the point where school districts already are required to let individuals know during that time period before the end of the school year what their employment kind of already looks like for the next school year. And I think, the other part to take into context is many individuals are creating their school budgets towards the end of the school year. So they have an idea of where things are going. It's not an added burden, I believe, on school districts, because as they're having these conversations to figure out what their budget looks like, they are working towards knowing both teachers, paraeducators, and other support staff, what that looks like towards the end of the school year. And so I think, we look at it from that standpoint. And then I will say, when we talk about the pay and stability of an individual, many paraeducators work second and third jobs to make ends meet. Many of them work periods of time during the summer, an extended school year, and other programs that are continued into those summer months for a period of weeks. So, I think we're not looking at every single person that's going to utilize this. This allows for some of those that have been in the field, I will say, the opportunity to have an option when it comes to that time, because this is and can be tough work. And so I think for us, it's not just about when we look at compensation, they also have to think about paying the bills during the year. And when you get into this field, it's for the love of the kids, it's for the love of education. And the hard work that they do is the support work for many staff members. And so there are multitude of things to figure out compensation wise. But when individuals get into this work, it's for the love of it. And as we continue to try to figure out how to properly compensate individuals, this is a good intermediate step. So thank you.
Representative Canino.
Thank you for indulging me for the second time again. I just had one question pop up while we were discussing this issue. So, and please correct me if I'm wrong, because this is a very new issue for me. But so, is it the case that before this bill is passed, you can only collect unemployment as a paraeducator if you do not have a reasonable assurance to return to work?
I believe without this change in statute, that would be the case.
Okay, and so this would make it so that if whether you do or don't have a reasonable assurance to return to work, you would still, so you would then get unemployment. So then my question is, why the reporting requirements? Why do we need to make a distinction between who is and isn't getting reasonable assurance in relation to the UI issue? Is it completely separate from that UI issue, or is it there's still some necessity for a reporting requirement?
I believe that the requirement of sharing that information with the Department of Labor will make it easier for the Department of Labor to make determinations should there be a question that is raised before them as to whether or not the person was properly denied unemployment.
Okay, thank you.
Any other questions? Seeing no hands, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 6, House Bill 7195, an act concerning unemployment benefits for paraeducators. This is a motion to JFS to the floor. The relevant LCO is 6593. Senator Kushner,
Yes.
Representative Sanchez.
Yes.
Senator Cabrera, Representative Wilson.
Yeah.
Senator Sampson, Representative Weir,
No.
Representative Hall, Representative Hughes, Senator Lesser, Representative Canino,
No.
Representative Gauthier,
Yes.
Representative Mastro Francesco, Representative Shake. Thank you, Madam Chair.
off the record for a brief pause. Back on the record, we're going to the next item on the agenda, which is item number 7, House Bill number 5607, an act concerning the subminimum wage for persons with disabilities. This is a JF to the floor.
Second.
It's been moved and seconded, and this bill, after hearing much testimony about wages paid to persons with disabilities, we felt it best to actually tackle this issue in a working group that would meet over the course of the next year and a half, that it would be required to report out its recommendations for the 2027 session. We think this is a complex issue, and there are strong reasons on both sides of the issue to address the needs of the community, to ensure that there's work for folks, but to ensure that it's properly paid. So we have put together a bill that will create a working group to a task force to address this issue. And this is a little bit unusual, is we will also be offering an amendment to the bill because of our procedures. It was a vote to draft. We drafted the bill. It was filed, but in reviewing that, we want to amend the existing bill, and I'll be offering an amendment. But just to describe it, it would expand the task force to include the chairs of and the ranking members of the Human Services Committee It would also expand the task force to include the Commissioner of the Department of Developmental Services, the Commissioner of the Department of Administrative Services. So those are the changes that will be part of the amendment that I will be offering. So why don't we start with my offering an amendment? Can I do that as the chair?
Yes, I just would like to confirm for the record that you give LCO the authority to make technical and conforming changes should this pass.
Yes, and that'll be, I'm going to read it in a
Oh,
second.
okay.
And it will say that. I didn't know that the committee would be that concerned with that part, but yes. This is an amendment I'm offering to House Bill 5607, an act concerning the subminimum wage for persons with disabilities. The amendment is to add, after line 9, add the following, quote, "2, the chairpersons and ranking members of the Joint Standing Committee of the General Assembly having cognizance of matters relating to human services or their designees," unquote. In line 23, strike the quote and the period, end quote, and insert instead a semicolon and a comma. After line 23, add the following, quote, 11, the Commissioner of the Department of Developmental Services or the Commissioner's designee, semicolon, 12, the Commissioner of the Department of Administrative Services or the Commissioner's designee, period, end quote. And we also would ask that the renumbering of sections and internal references accordingly and allow LCO the authority to make technical and conforming changes should the amendment pass.
Second.
It's been seconded by the chair of the Human Services Committee nonetheless. So the amendment has been moved and seconded. Is there any discussion on the amendment? Senator Lesser.
Thank you, Madam Chair. I just want to thank the committee for this amendment. I think it is we're currently, the Human Services Committee meeting is currently meeting next door, and we're very grateful to work with you on this issue and look forward to participating.
Thank you so much. Any other comments or questions? Not, I would ask the clerk to call the roll on the amendment. Can we do a voice vote? We can when it's an amendment. We'll do a voice vote then. All in favor? Opposed? Okay, the amendment passes. Now on the bill. Is there any comment or question? Representative Canino.
Thank you, Madam Chair. So we discussed this during the vote to draft, but I still have plenty of the same concerns that I raised back then, being that, yes, this is only a study, but as we know in this building, that studies become bills and many studies become bad bills. And I am very afraid in this study becoming a bad bill simply because of how the study is laid out. It seems that the intention is very clear within the language, that this is really looking for ways to end the 14C waiver program that allows individuals with severe disabilities to engage in gainful employment. If this program were to be taken away, it would take away opportunities for individuals who really have no other way to spend their day besides a day program. I've spoken to countless different advocates on this issue, and individuals who have engaged in this program, family members of individuals who engage in this program, and not a single one of them are asking for us to change this. And this really seems like a solution in search of a problem. These individuals are not being discriminated against. Their rights are not being denied them. They are being provided an opportunity to participate in our economy where they normally wouldn't be, because these individuals are in what's called group supported employment. So they might be with a group of their peers in a disability setting where they have staff that are there to help them, and they partner with a business who allows them to do a job at below the minimum wage that is commensurate with their ability to produce. So they are given a time study, they are rated on how well they're producing, and then their pay is made commensurate with that. And right now we have about 550 people using these waivers in the state, with a very large wait list of individuals wanting to use it. I think there were 2,600 people using this 5 years ago. It is a very popular program, and we heard that in the testimony that these individuals who utilize the 14C program, they see their parents go to work every day. They see their family members go to work every day. For many of them, it's not even about the wages. It's about the opportunity to do something that is not a day program, that isn't just playing games or coloring or going to the movies. It's something where they can actually create something and be proud of it and have some dignity. And every year it seems, or it might have been 6 months. I'm not sure about the time on this, but that time study is revisited. And if they are picking up skills and if they're becoming more productive, then their pay is increased. And some of these individuals actually end up making higher than the minimum wage because they're doing work in a prevailing wage scenario. So their productivity factors rated against the prevailing wage rather than the minimum wage. They receive career counseling in these opportunities, career training. But like I said, most importantly, at the end of the day, really for many of them is not the paycheck, it's the dignity of getting a job. And I understand the proponents of this bill might say, well, because this is so complex, we might look for solutions for different avenues, for different ways to provide employment for these individuals, to provide these opportunities. But I haven't heard a single one of those discussed. You might say that that's the purpose of the task force, but we should at least have an idea of what we're going to be looking at for opportunities outside of the 14C waiver program to decide whether or not they would even be close to proper. But at the end of the day, you talk to these advocates. If you take these opportunities away with no solutions, with no other alternatives, these people are just going to sit at home all day, or they will go back to the same day program that they've been doing day in and day out. These few treasure opportunities will be eliminated if this task force ends up taking place. It seems that the intention of this task force is very clear, that this program will be eliminated if this study is conducted, and for those reasons, I just cannot support this today. Thank you very much.
Thank you, Representative Wilson.
Thank you, Madam Chair. So I will say, when it comes to this bill, I will say it's a step in the right direction. Again, this is one that I know all too well, having several triplet siblings that are special needs, and one actually being in one of these programs. And so, I think when we look at putting together task force, I think when you look at this one, it's one that's going to consider all the issues. And so it's beyond just about finding opportunities, of where we're thinking we're going to get rid of this program, but understanding the ramifications that come along with the possibility of change. And so I do applaud the adding of our commissioners that deal with many of these individuals in DDS and Human Services, because this has a larger impact than just the opportunity for a job. This deals with individuals' benefits and their livelihood. And so when we look at a larger program, a larger opportunity of this, there are other things and other factors that are going to be discussed and thought about, because the last thing we, of course, want to do is move something forward that's going to negatively impact an individual's life or where they are today. And so I think when you look at this overall study group, its real biggest issue around is all of the potential solutions that come along with benefits and everything else to having these programs. They are beneficial. I can tell you that firsthand, watching the smile on my brother's face when he comes home from these employment opportunities. However, I do also know from individuals that testified and watching it every single day for the last 8 years of my sibling coming home just as tired as I do from work. And so understanding that while they may not produce the same level of work as every single person within a workplace, they work just as hard and feel the same thing that we feel every single day when we work an 8-hour shift. And so, it's applauding them on that opportunity. But this group is one that's I applaud a bill like this because it's not only addressing the opportunities that come with in the sub minimum wage for these individuals, but also the ramifications and possibilities outside of it. And so that we're not making a decision on something that is going to move forward and be a bad bill. We're thinking and looking at everything to see if it's the process for the program is the right thing, and how do we possibly fix it so that individuals can continue to be gainful of employment in our communities as well as in society. So thank you.
Thank you, Representative Wilson. And I just want to add that I have had the privilege of serving as chair to several working groups and several task force. And it's in each one of those cases, we've had people that have been put on designated as representing particular points of view, and often very divergent points of view. And it is the purpose to actually hear all points of view when we put together these working groups and task force. And this is one of the most serious issues I think that we have had before us. And it's not the first time. I've been here 6 years and I've heard this issue come up repeatedly. And it's being raised by persons with disabilities, and it's being answered or opposed by persons with disabilities. There is not a uniform view on this by anyone, including members of this committee. And there may not be a solution. Let me just start out by saying that the working group, this task force, may not find a solution to this issue. And we may be in the same spot that we're in now. But we have to at least try. After hearing this bill year after year come up, this issue come up in not just this committee, but I've heard it in appropriations as well. It's time to try and tackle it and see if we can find a solution that works for everyone. But certainly there's no one on this committee, including myself and my co-chair, that believes that we should deny opportunities to work to any persons with disabilities. That is not our intent. That is not what I think is going to come out of this working group, this task force. So I want to assure everyone that this is a real sincere attempt to get all the voices at the table and see if there are things that we could do as a state that would be better. And hopefully we will find some solutions, but if we don't, we're no worse off. So thank you for the opportunity to raise this bill. Representative Weir.
Thank you, Madam Chair. I'll be brief. We have spoken about this, and we heard testimony, some of it very moving. You know, this topic is a new one to me. I don't recall discussing this in the past year or two, and if we did, I somehow glossed over it. But this was caught my attention this year, and I did not have a chance to see the proponents who were with disabilities. I don't recall those people testifying, at least this time around. The working group, I got to admit, in our discussion, I agree with you that this is something that's sensitive. We don't want to deny opportunities to anybody, and I was inclined to support it. And then I've heard from a couple of constituents who are saying, you know, leave it alone. This is this is my son's or my child's opportunity at kind of getting out and feeling a sense of normal. That's me paraphrasing. We had no parents showed up here and spoke in support of this. We don't have parents specifically, and I know that they could be appointed. We could have parents represented here, but you know, it doesn't call out that it must be a parent of a disabled person on this committee, on the working group. And so you know, what I heard from the opposition, the supporting this bill were many people who aren't part of this community or aren't a parent. There were different groups who and different individuals who testified who I think had the best of intentions. I'm concerned, and I'm hearing the voices of the parents in my head saying this is a program that helps my son or daughter. Leave it alone. And so I'm support of the amendment, because I think having that additional bandwidth, if this does move forward, I think the language is good. But I'm hearing the parents say, leave it alone. This is, I'm afraid that something could come out of this working group that not only isn't a solution, but it could go in the wrong way where it takes these away. And I'm normally I don't let fear drive, but I'm letting that concern drive me, because the people who are involved in this program today, who are the 500 and change individuals who are taking advantage of this program and these opportunities, they're enjoying it. That's the testimony that we heard. So thank you for indulging me.
Seeing no other hands, I will ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 7, House Bill 5607, an act concerning the minimum wage for persons with disabilities. This is a motion to JF this bill to the floor as amended by Amendment A. Senator Kushner,
Yes.
Representative Sanchez,
Yes.
Senator Cabrera, Representative Wilson, Senator Sampson, Representative Weir,
No.
Representative Hall, Representative Hughes. Representative Hughes, we can't hear you.
Can you hear me now?
We can hear you now.
Representative Hughes votes yes.
Thank you, Representative. Senator Lesser, Representative Canino,
No.
Representative Gauthier, Representative Mastro Francesco, Representative Shake. Thank you, Madam Chair.
Thank you. I'm going to ask for a brief pause before we call the next item on the agenda. We are going to take a 5-minute break. We will reconvene at 12:18. Okay, back on the record, we're on item number 7 on the agenda. And that is House Bill number 5607, an act concerning the sub-minimum, oops, I'm sorry, we just did that one. We are on item number 8, an act, it's Senate Bill 525, an act concerning the selection of contractors for public works projects, and it's a JFS to the floor. Wait, it's LCO number 6639 now. Okay. Okay, this is a bill that would, hold on. This bill requires state contracting agencies to give preference to manufacturers, fabricators, and erectors located in the state when awarding contracts to build, renovate, or demolish a public building or public works project. If these in-state contractors are not available, the agencies must give the preference to those contractors located in the U.S. The S language here specifies that the bill's requirement applies regardless of the state contracting laws on competitive bidding and the lowest responsible qualified bidders. Comments or questions? Representative Canino.
Thank you, Madam Chair. And there are some very significant concerns here with what was just stated in the JFS, kind of clarifying a lot of the concerns that opposing testimony had. We saw that OPM and DAS testified against this because this concept is in clear violation of our state contracting standards. So the question is, what does preference mean in this state? When we are giving preference to in-state contractors, does that mean that an individual contractor who provides a service at a higher rate but lives in Connecticut or operates in Connecticut would be chosen over a Massachusetts company that can do it cheaper?
Yes.
Well, that draws significant concerns. To the people out there watching this, when your state builds a bridge, do you care more if the contractor building that bridge comes from Connecticut, or if that they are building it with the best quality at the lowest price, with the good stewardship of your tax dollars in mind? I mean, that's why we have contracting standards, to be good stewards of taxpayer money. And it's clear what this is. This would be, yes, benefiting certain select companies in the state of Connecticut. After we have kicked them in the teeth, frankly, as a state for years. But it's funny to me that the statement of purpose on this bill posits that this is intended to generate job growth and economic development. I'll tell you what, you could do that and more by reversing the vast majority of policies that have come out of this committee in the past few years. But we don't need to effectively propose trade barriers to other states in order to help CT create and retain jobs. All this is doing is saying that we are going to be worse stewards of taxpayer money, in that if there's a company outside of Connecticut that provides a service at a better rate for our taxpayers, we're not even going to consider them. Section 4A-59 of CGS already provides that, all other factors being equal, preference should be given to supplies, materials, and equipment produced, assembled, or manufactured in state. So if you have two companies that are providing a similar service, and that it's going to cost the state of Connecticut a similar amount, we are already providing preference to Connecticut companies, which I think is good to do if all things considered are similar. But if we're talking about leaving giving out a lot more money to these in-state contractors when another contractor out of state can do it cheaper, that doesn't put us in a better financial situation here in the state of Connecticut. And that brings me some significant concerns. Another concern that was raised in the testimony is, what is the definition of an in-state employer? For example, and through you, Madam Chair, what if the company is domiciled in another state, but it has branches or even just a warehouse in the state of Connecticut? Would they still be considered an in-state employer?
I don't know.
Well, that is a little bit concerning as well. I would hope that we could have some clarification on that, but I have some serious concerns with this bill. It really just further erodes the good stewardship of our public taxpayer dollars that our constituents, put us up here to defend, and I will be a no on this today. Thank you.
Thank you. Other comments or questions? Representative Weir.
Along many of those same concerns, I've seen locally where a town or municipality may have a cost preference where within a certain percentage, all things being equal, whether it be, the delivery of service, the time frame, there may be a slight preference given to a local contractor if they're located, domiciled, place of business is within that town. And I think that's more to benefit a small provider in a local municipality. But here, at a state level, with the hundreds and actually billions of dollars of money that we spend on contracting and improvements and alterations and repairs, that we wouldn't set an expectation that the quality is going to be equal, that the deliverables are going to be the same, how the workforce is set up. So I think we've opened the door to waste, fraud, and abuse, exactly what's being attacked in Washington through DOGE. We're going the opposite way here. I could look at some preference if we had some lines in here and some language that said all things being equal, preference will be given to the state contractor. But the fact that we don't have an answer on whether a warehouse counts as an in-state contractor, Madam Chair, I understand that you don't know, but that's not an answer that we should be passing this bill or any language out of here when we don't have an answer. This is a killer of competition. And what if this were reciprocal? What if Massachusetts this year decides to pass a bill saying we're going to give preference to Massachusetts contractors, and out-of-state contractors, we're not going to give preference to them. We're not going to give consideration to them. And now we've cut Connecticut jobs, Connecticut businesses out of work. And New York could just do the same thing, and so could Rhode Island, as a way of saying, well, we don't like the policy of Connecticut. So I think we ought to be careful what we ask for here. This could easily be cutting Connecticut businesses out of work when they do work in neighboring states or states that aren't neighboring. So I'll be a no on this. I hope the committee would consider reworking this or not voting this out of committee. Thank you.
Representative Wilson.
Thank you, Madam Chair. Just the one thing, and I mentioned this during the public hearing, is when we look at this, one of the things that I've had a front row seat on looking at is the racial disparities report, the state conducted. And we've had several individuals, I asked several questions about the opportunity of individuals gaining the opportunity to do business here in the state of Connecticut. And so I don't see this as a policy of shutting out other states. I think this is an opportunity for us to give some of those individuals that are employing hundreds of our residents here in the state of Connecticut in their businesses the opportunity to have pride in doing work here in Connecticut. And I think that's just, the biggest point here is that there are individuals that have been shut out of the industry with a lot of the public works projects across the state that are able to do the work. And so this gives us an opportunity to give some of those small employers, medium employers, even large employers, the opportunity from other sectors, the opportunity to do the work here. But it does not stop us from allowing the process still to continue of employers from outside of the state. But I think the other big part is that we're looking at, there are employers here in the state of Connecticut that have been shut out of many of these opportunities. And it's a way for us to really focus on truly generating some of that economic development here in our own state, but providing opportunities for many individuals who travel to other states to do that work because they're not allowed the opportunity or preference here in the state of Connecticut. So it's a step in the right direction. And it really, we can have the conversation day and night about where things go, but this is an opportunity for us to really give some of our residents here in the state of Connecticut that are going elsewhere to do business an opportunity to have pride in doing the work here in Connecticut. So thank you.
Thank you for those remarks, Representative Wilson. I do want to comment that we're always willing to and do almost always continue working on bills after they're voted out of this committee when there are necessary changes to be made or clarifications. So I assure you, Representative Weir, we're happy to look at some of these questions that you've raised and continue to think about them and discuss them as the bill works its way through our legislative processes. I do, however, I'm a little surprised, and I don't want to open up a big debate, but you referenced fraud. And I want to assure you that this is not intended in any way to promote fraud within the state of Connecticut. And I don't think that this bill would do so. I do think referencing DOJ, the federal agency that was created under the Trump administration as an administration that is now weeding out fraud and inefficiencies, I think there are plenty of people in our state who would take exception with that, especially given that so many of our neighbors have lost their jobs through nothing other than being a new hire or nothing other than seeing a department dismantled like the Department of Education. And so I would caution us from getting into a debate about it, but I didn't feel like I could ignore that comment and that reference to DOJ in this context. But I assure you, there's no intention on the part of anybody in the majority to create a situation that would cause fraud or inefficiencies in the state of Connecticut. So having said that, I would ask the clerk to call. Sure, Representative Weir.
Thank you, Madam Chair, and I didn't mean to insinuate fraud, but I will tell you, when we kind of tighten down the contracting even more than it exists today, to give preference the only consideration is whether a business is located in Connecticut. I think we really tie the hands of people that would otherwise be making those decisions, and we limit the choices and lower the competition. So generally with lower competition, we see higher prices. That is what I was trying to make the connection. And thank you for that.
Thank you. Seeing no other hands, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 8, Senate Bill 525, an act concerning the selection of contractors for public works projects. This is a motion to JFS to the floor, and the relevant LCO is 6639. Senator Kushner.
Yes.
Representative Sanchez.
Yes.
Senator Cabrera. Representative Wilson.
Yes.
Senator Sampson. Representative Weir.
Nope.
Representative Hall. Representative Hughes. Senator Lesser, Representative Canino,
No.
Representative Gauthier, Representative Mastro Francesco, Representative Shake. Thank you, Madam Chair.
Thank you. We will be holding votes open. Item number 9 on the agenda is House Bill number 7197, an act requiring paycheck transparency. And this is the JF to the floor. Is there a motion?
Okay.
It's been moved and seconded. This bill would require employers to provide a glossary of sorts to employees to explain, that would explain the acronyms that were so often found on paychecks. So an employee would be able to decipher and then discern whether or not they had been paid correctly. Any questions or comments? Representative Canino.
Thank you, Madam Chair. I discussed this one at length in the public hearing, so all my questions were pretty much answered there. Just a comment. This is another unfunded mandate on our businesses. Individuals are already able to request a detailed summary from their HR staff on how that paycheck is to be broken down. If they are given a list of acronyms, they can ask that staff to explain them. Requiring it to be printed or requiring a guide to be created is just another costs that we're putting on our employers who are already facing rising labor costs, rising supply costs, rising compliance costs with the regulations that come in year after year. And to me, this does nothing that isn't already available to each one of our workers. So I will be a no on this today and look forward to any further discussion. Thank you.
Thank you. Any other comments? Representative Weir.
Madam Chair, the pay codes that you alluded to or referenced, the glossary, if it were, these are already terms that are specific to each business. Through this bill, we're not requiring the employer to adopt a standard set of pay codes, right? Correct? This is if company A may have certain set of pay codes and company B may have a different set. And this is only asking that employer to post their own pay codes.
That's correct.
Okay, and these already exist within the company. They don't have to create any new ones. Somebody in HR has these in order to code the timesheets. All we're asking here is that whatever those codes are transparent to the employee.
That's correct.
Thank you.
Any other comments or questions? Hearing none, then I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 9, House Bill 7197, an act requiring paycheck transparency. This is a motion to JF to the floor. Senator Kushner,
Yes.
Representative Sanchez. Senator Cabrera, Representative Wilson. Senator Sampson, Representative Weir,
Yes.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Canino,
No.
Representative Gauthier, Representative Mastro Francesco, Representative Shake.
Yes.
Thank you, Madam Chair.
Thank you. Now we will move back to items number 2 and 3. We will be taking up item number 2 today, but we're going to hold on item 3 for a later agenda. Item number 2, Senate Bill number 1035, an act concerning limitations on the use of non-disclosure agreements. JF to the floor. Is there a motion?
Second.
It's been moved and seconded. This is a bill that would limit the employers from entering into non-disclosure agreements that would then would protect the employer, or actually it protects both the employee and the employer from non-disclosure. They would be people would be not be able to enforce the non-disclosure parts if the employee reasonably believes it to be legally impermissible, discriminatory, harassment, retaliation directed at an employee, a wage and hour violation, or a sexual assault, or that it is recognized as a clear mandate of public policy, and 2, occurs at the workplace at work-related events between employees or between an employer and employee, whether or on or off premises. Any comments or questions? Representative Canino.
Thank you, Madam Chair. So last week we had a bill dealing with non-competes. Here we have non-disclosures, kind of a similar arena, in employers having an interest in protecting either proprietary knowledge or just having control over the ways in which they hire their employees, the requirements that they put on those employees. So the first key issue here is that this bill prevents an NDA to have any term in it preventing someone from disclosing information about a situation where they reasonably believed that discriminatory employment practices took place. Saying it is discriminatory practice to discharge someone from employment for violating an NDA where they were not supposed to disclose any of this information. And it seems to me in this bill that it makes any current, former, or future NDA regarding this behavior null and void. Madam Chair, is that the case, that this would be making previously entered into NDAs null and void if they have this provision in there?
Yes.
Okay. Well, that's concerning because now we are interfering with legally entered into agreements between employers and employees that have already happened. And there's a big concern there, but I think the biggest part of this that interested me that I was unaware of during the or before the public hearing was that many times these NDAs are actually a part of a settlement agreement. So an individual who feels that they were discriminated against may, instead of going through a lengthy trial process that could be very taxing on them, not only financially, but emotionally, they might say, hey, I'm willing to sacrifice my ability to speak on this issue, and I'm going to take some sort of compensation. And I think that that is definitely something that is reasonable for someone to engage in. So this would actually be taking away that option for them. And if this bill were to pass, those individuals would not be able to negotiate their silence for compensation. And it doesn't seem like this is just encompassing, the things that you would think of in terms of discrimination that would first come to mind, like race, sex, color, creed. But as we saw in the testimony, it will seemingly encompass labor disputes, wage and hour violations, and a wide range of other legally impermissible behaviors. This reduces an individual's ability to prevent a lengthy trial, and it is going to encourage employers to actually take this to court, which could result in very high attorney fees, not just for the employers, but for the employees as well. But to get back to the first issue I discussed of someone reasonably believing that a discriminatory employment practice took place, that seems like a very broad standard to me, and it is really taking away due process for the employer. We're not talking about a situation where things were adjudicated, an employer was clearly found to be in the wrong. We're talking about where if just someone believes, someone's own belief, someone comes to their own conclusions in their own mind that discriminatory action has taken place. To me, that really is troubling, because people can have very broad imaginations. And I'm not trying to trivialize anybody's individual experience who has suffered real discrimination, because we know that that does happen and it is abhorrent. But this really opens up employers for a broad range of instances where this can actually happen. And then if employers are found to be violative of this, again, here we're talking about a $10,000 fine at a time where we are trying to encourage more businesses to come to Connecticut, where Connecticut businesses are struggling with increased labor costs every year. Slapping a $10,000 fine on this if they violate it in any way. During the public hearing, I asked a question of the proponent of, was this meant to bar employers from requiring confidentiality standards for HR professionals pertaining to incidents that occurred to another individual? So through you, Madam Chair, for legislative intent, would this bar companies from imposing confidentiality standards on their human resources staff?
I believe that was answered during the course of the hearing, and the answer was no.
Thank you. And the reason I ask again is because after the hearing, after going back and looking at the language here, it really does seem that there would be an issue with imposing those requirements on HR staff, because, and forgive me for reading, but it's important to this point, that it basically, I'll summarize, it would be discriminatory practice to require or request a prospective current or former employee or independent contractor to enter into an agreement containing a provision that is void pursuant to subsection E of the section, and basically saying that you cannot require an employee to, let's see, sorry, just need to find this real quick.
Excuse me, are you referring to lines in the bill?
Yes, line 210, starting at line 210. So an employee or independent contractor, because such person disclosed conduct the person reasonably believes to be a discriminatory employment practice. So we're talking about preventing NDAs from requiring somebody to stay silent on issues where they are disclosing discriminatory, the fact pattern in a case where they reasonably believed discriminatory employment practices took place. In this language from line 210 to 227, it does not seem to make any distinction between one's own experience or another person's experience. All it's saying is that if within that company, an individual believes that a discriminatory practice took place, there's nothing that the employer can do to prevent them from telling anybody that they want about that. So to me, it really does seem like this would prevent HR officials from having confidentiality requirements. Because if an HR official is observing a case that they're dealing with, that they're helping to adjudicate with the company, and they believe that, and then the employee discloses to them that this conduct took place, and then that HR official determines in their mind that they reasonably believe that discriminatory employment practices took place, then they would be under this bill. It seems to me, they would be allowed to disclose that in violation of any NDA that they previously signed on to. Am I misconstruing this, Madam Chair?
I think I answered the legislative intent question that you raised. If there is a concern about it that has not been answered, that's the kind of thing that we could certainly discuss going forward.
I appreciate that response and the willingness to work forward on that, because yes, it really does seem like there's a kind of a blind spot there. But the most frustrating part of this bill, that for me, at least when we were discussing this in public hearing, was the talk of sophistication. That yes, individuals are signing these NDAs, but they might not be sophisticated enough to understand what they are signing away, especially in some of these instances where they're signing away their right to speak about an incident in a settlement agreement. Our workers are very sophisticated in this state, and I would love for you to be able to find me an individual who doesn't understand what an NDA is when they're settling one of these types of complaints. So I just I hope in the future we could stay away from that type of way of speaking about this issue, talking about, calling certain types of workers unsophisticated. But yeah, for those reasons and many other, I will not be able to support this today. This is just, again, violating consensual agreements between employers and employees. It is taking away one tool an employee has to avoid lengthy litigation on these issues. If they want to, they can use these to guarantee them a certain settlement in the short term rather than drag it out. And we are taking away their ability to really negotiate here. No one wants to see anyone discriminated against, and no one wants to see anyone silenced. But if that individual consensually agrees to that in exchange for compensation, who are we to get in the way of that and stop it? Again, it just seems like a very wrong intrusion of government into private contracts between individuals. And for that, I cannot be supportive of this today. So thank you very much, Madam Chair.
Thank you. Other comments or questions? Representative Weir.
Thank you, Madam Chair, and I will, I made my notes prior to coming to today's meeting, so I will do my best not to duplicate. I'll try to catch myself as I'm going through here, not to duplicate what my colleague brought up. So where we talk about the new section of the bill begins at lines 207, and essentially it's backing up to, this just is tacked on to all the other items before it, which began on line 20, and it basically, it shall be a discriminatory practice in violation of this section. And now we get into the new section. And we talk about the standard that the employer is held to. And the standard is that the employee reasonably believes that they were discriminated against. Madam Chair, how do we determine, and I don't think I'm duplicating what my colleague asked. I know he talked about reasonably believe, but how do we arrive at an employee reasonableness standard?
I believe that the way this is drafted, it would be up to a court to determine whether there was a reason, whether the employee could reasonably believe that. And I think these standards, the standardness of reasonable it's a legal standard that's often used in statute and in contracts to provide guidance to the courts.
Thank you. So I, for the most part, understand a reasonableness standard. I believe I do. And you're saying that that's typical. What concerns me here, and again, it could just be the way I'm interpreting it, is that the person, that the employee reasonably believes he or she was discriminated against, or maybe witnessed a saw a potentially discriminatory practice. My concern is that one employee's version of reasonable may be different than somebody else's in terms of, you know, if the employee is in an office environment and he or she feels that, you know, they make maybe make an unreasonable request of the employer and is, the employer doesn't comply with that because the employer believes it's an unreasonable request, and maybe that's a different seating assignment. I'm trying to think of an example where the employee, there are probably 50 of them, different examples that could be used where the employee feels it's a reasonable request. The employer doesn't grant that request, and now the employee makes an accusation that the employer has retaliated. Maybe they asked to have their seating, like I said, their seating assignment moved, or they make an accusation that is unreasonable. They're disciplined for it, and now any NDA. My concern is that we've opened this up too much. Does that make sense? How do we deal with an employee who's made an unreasonable request, but thinks he or she has made a reasonable request?
I believe the way this is drafted, that the employee reasonably believed that a legally impermissible action had taken place, which is different than just saying, I didn't get the assignment I wanted or the seating. It specifically is addressing discrimination, harassment, retaliation directed at an employee, a wage and hour violation, or sexual assault. So, I mean, I think this isn't to every request that an employee makes on their employer.
Thank you for that. On line 218 to 221, talks, I'll just read it so I'll make sure that I don't paraphrase. An employer who violates the provisions of this subdivision shall be liable to an employee or independent contractor for actual damages or statutory damages of $10,000, whichever is more. Who determines if the employer committed a violation?
I believe this would be determined in a court. There's created in this bill a civil cause of action.
Okay, so after the employee has to make a complaint, the employee has to bring an action, and the court will determine then if the employer violated the provisions of the statute.
Give me one. I want to correct my statement. This would be enforced by CHRO, not a court of law, this section.
Thank you. Madam Chair, just for my edification, where is CHRO referenced in this bill somewhere else? Did I miss it? Or is that just how the process works? I just don't understand how we jump to CHRO.
If you give me a minute, I'll find the reference.
I see something on line 290. But I didn't see my question referenced that.
It might be in the underlying statute. In the underlying statute.
Oh, never mind. That's right.
Yeah. Just for the record, this is the reference to CHRO is found in the underlying statute.
So, Madam Chair, so in line 1, when it talks about 46A-60, that's where the CHRO reference is found. It ties back to that.
So the chapter 814-C is the CHRO statutes, and this section 1 references repealing section 46A-60, and that is found within the CHRO statutes.
Thank you for that answer. Madam Chair, on line 223, and I'm going to read again with your permission because I don't want to paraphrase this. The provisions of this subdivision and subsection E of this section shall be liberally construed so as to effectuate their remedial purpose, and such provisions shall extend to an intern. So what is up until shall? The provisions of the subdivision and subsection E of this section shall be liberally construed so as to effectuate their remedial purpose, and such provisions. What does that mean?
That means that the CHRO folks, the people who will be adjudicating this, will understand that these are to be liberally construed. And I do believe this is statutory language, that it is understood by the courts, and in this case by CHRO. So they understand how they should view this language or interpret it.
Okay, so I'm interpreting that, so that's, they'll interpret it broadly, is that,
I would assume, yes, that that's correct.
thank you. Yeah, again, I don't have too much more here. I do have concerns that we have throughout the bill. Reasonably believed that we have we've extended that courtesy to the employee, but the employer may reasonably believe that what they are doing is perfectly allowed. And I think by allowing the employee to determine that standard that's how I interpret this, that by allowing the employee to determine what's reasonable, it becomes a perspective thing, and the employee may be making something unreasonable that he or she views as reasonable and brings an action as a result of that, which gets the employer involved with CHRO as a result of this. So I have grave concerns seeing reasonably believed throughout this document. Again, I know it's some of the old language as well as the new arbitrary number of $10,000. I cannot support this today. I'm concerned the message that sends that two people are not able to come to an agreement, that this takes previous agreements and makes them null and void. Many of the arguments that Representative Canino made, so I won't camp on those, but I'll be a no today. Thank you.
Thank you. Senator Sampson.
Thank you very much, Madam Chairman. Yeah, so my colleagues have done a good job of pointing out some of the concerns with the bill that is before us. And just to recap, we're talking about, this is Senate Bill 1035, an act concerning limitations on the use of non-disclosure agreements. And would it be safe to say, Madam Chairman, that the purpose of this bill is to prohibit the future use of non-disclosure agreements and also to eliminate the validity of any non-disclosure agreements that are currently enforce contracts through you?
This bill would limit the use of NDAs, and it also does very specifically for employment contracts with NDAs that were entered into before October 1st, 2025. The bill makes provisions void and unenforceable only if they were entered into at the outset or during the course of employment. And it also limits an employee's recovery of damages to the cost of preventing the NDA from being enforced.
Thank you very much for that answer, Madam Chairman. So if it only makes them, the reciprocal prohibition applies to ones that were part of someone's initial employment and were added or were added during the course of their employment.
Correct.
So am I to understand that it would still be acceptable for someone who has some sort of dispute with an employer to enter into an NDA at this point that didn't pre-exist as part of their contractual employment arrangement?
I'm sorry, could you repeat that question?
Yes, ma'am, certainly. So the reciprocal prohibition that we just started talking about applies only to non-disclosure agreements that were part of the original employment agreement or were added as part of a change to their employment arrangement at some point. Does that mean every non-disclosure agreement, or would it still be acceptable for the parties to engage in an NDA prior to the date that this bill becomes effective through you?
I'm not entirely sure I understand the question, and I know you've stated it twice. But if you want to give me a minute, I'll see if someone else does. So just back on the record, I believe I will state what I think your question was, although I'm still not 100% sure. But if if an NDA, if a court case was settled, if there was an agreement reached prior to October 1st, 2025, that would still stand. However, if someone has a lawsuit on now, or let's say a new employee entered into an agreement before October 1st, is this your question? Would that agreement be null and void? And the answer would be yes. It would be the same circumstances as the other employees that I addressed. Maybe I still don't get your question. Go ahead.
Thank you, Madam Chairman. Yeah, so I guess it's very similar, the response to what I'm asking, but it seems like the bill is written in a very specific way to say that it's going to prohibit the validity of an NDA that was entered into in the past between an employer and an employee, or something that happened during the course of that employment. But it doesn't prohibit one that happened afterwards, maybe as a result of a certain situation.
Let me clarify. I believe that the difference is that if an employee has left employment and then settled an agreement after they left employment, this would not disturb that agreement. This would only apply to people who are still employed, I assume, and may have signed an agreement on the onset of their employment or during their employment prior to October 1st, 2025. And let me just check with our OLR folks that I said that correctly. Okay. I did. Continue.
Thank you very much, Madam Chairman. I appreciate that answer. And the reason why I bring it up is not just, trying to find a hole in the bill or anything like that, but I'm concerned about the certainty with which businesses will be able to carry on in the future, based on these agreements. If the bill is very clearly states that, all NDAs that have pre-existed are no longer valid, and it says that you cannot make one in the future, some people might be opposed to such a policy, including me, but at least it would be a clear policy. My concern is that by creating these different methods of handling this retroactive prohibition, what you're doing is effectively creating some uncertainty about which non-disclosure agreements may still remain valid. If there is a non-disclosure agreement that is entered into as a result of some sort of incident in a place of employment prior to this bill becoming law, does that will that still be enforced is, I guess, the question that I have, or are the parties free to ignore that agreement and contact the press or authorities or something like that through you?
A non-disclosure agreement that was signed between the parties will not be enforceable. The only instance where it would be is if the person had left the employment and settled a case or settled a complaint by virtue of with a non-disclosure agreement.
All right, thank you. I appreciate that answer. But so somebody is still employed with a company in my example, and they have an incident and they settle and they make an agreement that includes an NDA, and the employee is actually awarded a sum of money. Are you suggesting that if this bill passes, then that employee does not have to honor the NDA, even though they were awarded a certain cash award? They can continue. They can just pretend they never entered into it. Is that correct?
Well, I'm not saying that they pretend, but I'm not agreeing with that part of your comment. But generally speaking, what you asked is the answer is yes.
Thank you very much, Madam Chairman. And how far would this go back? To anything that happened prior to the bill being passed. Is that correct?
That is correct.
Yeah. Thank you very much, Madam Chairman. Yeah. So I would say that that's quite concerning. There are some, significant entities that exist in the business world that have hundreds, maybe thousands of employees, and who knows what the various agreements that they've entered into for various purposes that could be construed to fall into the category of an NDA. And a lot of times people are compensated initially for an NDA when they take on an employment, but certainly if there's ever a dispute over a specific incident, and to suggest that even if somebody's been paid off, that they don't have to honor the agreement, to me is shocking. And I'm surprised that that is the intent of the bill. Madam Chairman, does that interfere with any constitutional protections that someone might have regarding contract law or freedom of speech or compelled speech or anything like that? Is there some danger that provision in this bill that would allow someone to negate a contract that they've already entered into? Does that violate any part of our case law through you?
I don't believe so.
Thank you, Madam Chairman. Can you think of another situation where the state government has passed a law that negated a contract that pre-existed where someone was already compensated?
I'm not aware of any. I haven't researched that in anticipation of your question. So it could exist, it could have happened, but I can't at this moment provide you that detail.
Thank you, Madam Chairman. And what's the purpose of that? Is it to undo something that the parties have already agreed to and someone's already received a payment for. What is the compelling state interest for such a thing to occur?
I think that it's important that if there is an employer or an employee of an employer that violated our laws and could have even engaged in behavior that was violent or very damaging to another employee, harassing, sexual assault, rape, we've heard about. We've heard about cases where there were non-disclosure agreements that prevented the person from bringing that action forward because of a settlement that was reached. And I think the state has an interest in not allowing that not in prohibiting non-disclosure agreements, because it does impact other employees, because that person who committed those illegal acts may still be employed and may still be subjecting other persons to that illegal behavior, those illegal acts. I'm not sure I'm saying this well, but I think you understand what I'm saying.
Thank you very much, Madam Chairman. I do appreciate what you're saying. And you're very specifically referring to things that are criminal in nature and certainly behavior that should not be condoned. But am I correct in understanding that in order for a non-disclosure agreement to exist, it does not have to rise to the level of criminal behavior? This could just be something that the company does not want disclosed because it's embarrassing, but it's otherwise not illegal, and the employee agreed not to disclose it in exchange for a certain sum of money. And what we're understanding, discussing the bill, is that agreement will be null and void, and that person, even though they've already been paid, they can go and spread the word now about what they learned. And it not having to do with, am I correct that it doesn't have to do just with criminal acts?
It has to do with illegal activities, not necessarily criminal.
Does it have to be illegal?
I believe that the disclosure and the non-disparagement clauses that we're talking about involve an employee who reasonably believes that a legally impermissible discrimination, harassment, or retaliation took place, or a wage and hour violation, or a sexual assault. So it's a broad categories, but it doesn't necessarily, it's not restricted to criminal behavior.
Well,
but it is illegal.
Well, thank you very much, Madam Chairman. Well, you ended your comments by saying it is illegal, but the rest of your comments were about how the employee needed to reasonably believe that it was illegal. And I don't even think that's accurate, to be frank with you. I think that the bill extends to things that are patently not illegal. But even if that was the case, it is not things that are illegal. I just want to clarify with you that it is, in fact, what the individual reasonably believes to be a violation of discrimination laws or public policy.
Was that a question?
Yes, ma'am.
I thought you were restating my point.
I'm trying to make a distinction between something that is in fact illegal, or it's only the requirement is that the individual reasonably believes it's illegal. And just looking for your clarification.
I believe it's an employee reasonably believed to be legally impermissible. But I do believe that if they're going to be able to enforce that, then there's probably going to be a determination as whether or not that was reasonable. I think that's what I said earlier about CHRO.
Thank you very much, Madam Chairman. Forgive me, I'm waiting for your consent to continue speaking sometimes. That's why if we're looking at each
Continue
other.
speaking.
It's okay.
Please
I like
continue speaking, Senator Sampson.
Thank you, Madam Chairman. I just like to follow the protocol of the committee.
I
if possible.
agree. That's good.
So, the thing is that, this reasonably believes language, which was already mentioned a few times, is not a small thing. It's a huge thing. In fact, it is what makes what is already a bad idea for a bill into a positively insane and hostile idea, because that's what's going on here. Effectively, you are enabling frivolous claims by employees or contractors that don't have any objective proof that any criminal activity was going on to use this as a mechanism to harm an employer. And you're creating uncertainty for employers who need to be able to enforce legitimate confidentiality agreements, that have existed in the past, and banning them in the future is a whole other conversation we're going to get into in a minute. I'm just worried about what's going to happen to the folks that are out there in the world now. There are a number of dangers to this policy, but this vagueness when it comes to the notion that it's reasonably believes standard also is going to.
Hold on. Let's take a pause. And there's that button there. I apologize. I was distracted as just for those out there that are listening, as my colleague is so fond of saying, there are many committee meetings going on at the same time, and sometimes our committee members need to vote on a bill. And so that's why there was a little bit of noise here, but it's been addressed, and I apologize to my ranking member. Would you please continue?
Thank you kindly, Madam Chairman. No problem. These things definitely happen. I was just kind of going off on the reasonably believes language in the bill, and the dangers of having very vague terms like that contained in bill language. As all of us have mentioned, I think even today, when you write a law, it ought to be clear to everyone involved. People should understand it. You shouldn't have to go check with an attorney to know what it means. And I understand it's plain language, but it's plain language that opens the door for a lot of frivolous, claims and uncertainty for employers going forward. The other issue I have with this bill is that I think that it absolutely violates the rights of the parties to privately contract, which in my view is a cornerstone of our American system, that people can engage in private contracts with one another on a multitude of things. And a non-disclosure agreement is a voluntary contract. No one has the ability to force another person to sign one. I know that there's arguments made all the time about how the employer is in a position of authority over the employee. I mean, that may or may not be true. There are plenty of cases where the employer has, or the employee has, the leverage of the employer. The fact of the matter is that, in both cases, it doesn't matter. No one's got a gun to your head to sign the agreement. And if they do, then that agreement is void because we have laws to protect against that. So when you start to make the argument that we're doing this because one side has the ability to force the other one, that's not true. If you are putting undue force on someone to sign an agreement, that is already against the law. And my concern here is that, this bill is being sold by the proponents as protecting people. Oh, we're protecting people. We're protecting people that were abused. There may be some net result of that, but you're also denying those same people rights. And I have said many times before in this committee and other places that I'm never going to vote to deny someone their rights, even if they want me to. Rob, vote to take my rights away. No, I'm not doing that. Thank you very much. Even if you don't want to exercise your right, then don't exercise it. No one's making you. But the idea that the state government can pass a law to deny someone their rights, to me, is problematic. And that's what this bill does. This bill tells someone that they cannot negotiate a settlement with their employer in exchange for confidentiality. That is a denial of their right to do so. And sometimes I believe that is the best solution for that employee. And coincidentally, why they chose it. Let's put ourselves in the shoes of something happening in the real world where there is an incident that happens in a workplace and it's an uncomfortable situation, and the employee is now faced with a choice. They can either go to the authorities and expose the issue and go to court and maybe have to go through a lot of difficult times and public exposure and drama, or they might be more willing to go to the employer and exchange a few promises, like a settlement and a firing of the employee that was responsible that caused the problem, maybe a change in policy, something like that. All that's out the window with this, because effectively you are taking away that employee's right to negotiate the terms of their non-disclosure. The fact of the matter is that I believe that non-disclosure agreements that happen as a result of some sort of bad behavior are more often than not suggested by the party that was harmed than the employer. And that's a result of the fact that sometimes that is the best possible result for them. And that choice right now is up to them. Because if it was suggested by the employer, they can simply say no and continue to pursue what they want to. This takes that right away from them. There's no additional benefit to this legislation, is what I'm trying to say. It's not like anybody gets anything extra. If that employee actually wanted to go forward to pursue someone criminally or through their liability for what occurred in the workplace, then they can do it. There's nothing stopping anyone right now. The decision to sign the NDA is theirs until it's not, which is what is being created in the bill that is before us. And to me, that is a shame. And that's why I get so frustrated sometimes when I hear the way these bills are described, the way these bills are reported on, some of the way the testimony goes. People are failing to acknowledge the fundamental truths about what's happening. Oh, we're doing this because it gets rid of the gender pay gap. Okay, that's one side of the story, but what does the bill actually do? And in this case, what this bill actually does is it denies the rights of victims to be able to negotiate terms that they're happy with. That's what it does. Do you disagree, Madam Chairman, that this bill would prohibit the right of a victim to negotiate a non-disclosure agreement with their employer if they choose?
This bill could not be, non-disclosure could not, because of this bill, an employee would not be required to adhere to a non-disclosure agreement, even if they'd already negotiated one.
I think you agreed with me. I mean, I tried to.
I'm not going to agree the way you framed it, but I understand this. And I think I said earlier that my belief is that this bill will protect people in the workplace going forward, because somebody who has committed an illegal act, there's no prohibition on anybody, even if there was a non-disclosure, a non-disparagement agreement signed, there would be that would not be enforceable any longer. That's my answer. Please proceed, Senator Sampson.
Thank you, Madam Chairman. The reason why I did that is because you interrupted me a couple of times during our conversation today, and I'm not trying to be disagreeable, but I was in the middle of a sentence, and that's the reason why we have a protocol, and that's the reason why I try and stick to it, because I don't want to be interrupting you and being disrespectful. The question I asked was a very straightforward question, and if you disagree with the question, you're certainly entitled to, but I'm going to ask it again as clearly as I can, because I think this is important. This is the most important key ingredient. Will this bill proposal deny the right of an employee who's been aggrieved to suggest and enter into a non-disclosure agreement with their employer if that is their choice to do so? Through you.
And my answer is that if that were to happen, then it would not be enforceable.
Thank you, Madam Chairman. Does that mean that the bill doesn't restrict the creation of non-disclosure agreements? It just makes them unenforceable?
What I think I've been clear about is if I can't go and tell an employee, I'm not going to be on the scene, neither are you. None of us are going to be on the scene. If an employee were to suggest to their employer, as you've asked, that they want an NDA and they were enter in an NDA, that agreement would not be enforceable. You asked the question, I'm taking it very literally. You asked the question whether or not they could do this activity. What I am saying is we can't control what people do in a work situation. We don't know if that person was even aware of the laws that we're passing, but I can answer with certainty that it wouldn't be enforceable.
And thank you very much, Madam Chairman. So the net result is the same. It says even if such an agreement was agreed to by the parties, then it would not be enforceable. So in effect, I'll stand by my assertion that the employees being denied their right to enter into an NDA of their own free will because they feel that's what's best for them. And before anyone votes on this bill, they should keep that in mind, that this is not just about restricting employers. This is about restricting the employee's rights. That's what happens here. The employee loses their rights and potentially loses the only actual recourse they might have in some situations. Because as was mentioned, this bill doesn't have anything to do with what is actually illegal. It is only what someone reasonably believes to be a violation. And that is a far different thing. I'm concerned, by the way, that by interfering with this ability for the parties to privately contract and come up with a mutually beneficial resolution to the problem, that you're going to end up with situations that are not only frivolous, but they're going to end up with situations which actually harm the parties based on false and exaggerated claims. I mean, the reason why people enter into these agreements is because they don't want to go through the public drama of going to court or filing charges, etc. And that applies not just to the employer. I mean, I think this is a very one-sided view of things to suggest this is only NDAs only exist to protect employers from being exposed for having, bad activity go on in the workplace. This is also to protect employees who do not want to be dragged through the mud, have their reputation harmed, or have to go through a prolonged, protracted court battle. This is a way for them to get some sort of justice in the short term through a mutually agreed to contract that they have the power to determine for themselves up until this legislature takes that freedom from them. It effectively removes an individual's autonomy to settle their own disputes in their life, which just goes right to a denial of personal freedom, in my view. Let me just ask some questions about how broad this bill is written. I mean, we already talked about how it's broadly written to describe reasonably believes. But let's talk about this language about where this bill applies and to whom it applies. There's a whole section that goes on about, forgive me, I'm just trying to get to the right page. I think it's on lines 313 through 332 that extends into the range of work-related events coordinated by or through the employer, comma, and these are all separate things that are included in this policy between employees or volunteers, comma, and here's another situation, or between an employee and an employee or volunteer, and then finally, whether on or off the employment premises. This strikes me as unbelievably broad. So you're suggesting that this policy is going to apply in cases where you have two employees that are at a non-employment event or off the employment premises. Is that right through you, Madam Chairman?
Yes.
And it also, in my view, reading the language, it also extends to volunteers, which are people that are unpaid effectively, but I think they're being treated as employees in this context. Am I right about that?
Yes.
Can I ask, Madam Chairman, why we would go so far to include all of these additional situations and individuals that the employer is going to have a very limited responsibility over, except when you create that responsibility in this bill, under normal circumstances? I mean, I can understand someone who is an employee while on the at their place of employment on the job. The employer can have some ability to manage and monitor what behavior is going on, but that is going to get increasingly less enforced as you get farther and farther away from the place of doing business. What is the purpose of holding the employer responsible in such broad terms through you?
I think it's clear that some of the actions, the illegal actions that have happened between employees or between an employer and employee have happened off-site, and that's not uncommon. And so this bill intends to make it clear that those actions are also covered.
Thank you, Madam Chairman. I noticed in line 323, the term says legally impermissible. Does that mean that it's a crime because it's against the law through you?
It means it's unlawful.
Is there a difference between being unlawful and being a crime through you?
I'm not sure, because crime might imply, and I'm not an attorney, but it might imply in your question that it had to be a criminal activity. It could be an illegal activity.
I thank you very much, Madam Chairman. I appreciate the answer, although I don't know that we cleared it up at all. But let's just say that this is something in violation of a state statute. Would that include regulations that are promulgated by the various state agencies and bureaucracies through you?
I would assume so.
And what if it was something that wasn't unlawful, but it was simply something that might rise to civil litigation, or somebody might end up having liability for their behavior, but they didn't commit a crime?
I think that was what I was referring to, that it might not be criminal activity, but it would be in violation of state statutes or regulations.
Thank you very much, Madam Chairman. I think we're talking about three different things now. There's what is a crime, which we can't seem to nail down. So I kind of moved away from that. So I'm just trying to stick to whether or not something is a violation of the law and or regulations, or it's something that just someone could have liability for in a civil arena. And I'm curious if this section includes only things that are violations of statutory law or regulations, or it does extend beyond that through you.
So could you please describe to me, because I'm not a lawyer, what you mean by would be civilly responsible for? Restate it, because I might not have the exact term you used, but you talked about civil.
Thank you, Madam Chairman. I'm not a lawyer either, but I do recognize that, people are sued every day, and they go to court and they have civil litigation where someone is found liable for their actions, and they have to, pay the offended party, or their insurance company might have to. But they are not always criminal in nature, these activities. I mean, it's certainly, if you have, you can think of a lot of things, like you accidentally, break your neighbor's window or something like that while you're cutting down a tree limb or something like that. There's no crime involved, but you are still responsible or liable for the damage that you've caused. And I'm just asking whether or not this section here that applies to volunteers would go beyond things that are actually against the law into that arena of things you just become liable for through you.
Well, I think there is some reference earlier here about public policy, so perhaps that's what you're getting at.
I'm asking about the paragraph 313 to 332 regarding volunteers.
Yeah, I am looking at 313 to 332. And what I'm referencing is online 320. It says, or that is recognized as against a clear mandate of public policy.
Thank you very much, Madam Chairman. The reason why I'm asking these questions, by the way, is because the language in this section is unbelievably vague, including what you just stated to me. I mean, first off, it says that on line 316, that the employee or volunteer reasonably believed, again, under state, federal, or common law to be legally impermissible discrimination, legally impermissible harassment. I don't know. There might be legally permissible harassment that implies that there is directed at an employee or volunteer and so on. So I'm just trying to get to the bottom of what's covered by this or not, because first off, you have the reasonably believed portion, which does nothing to protect the employer. This now only is up to that individual volunteer, what they reasonably believed. And then it doesn't even go so far as to suggest that it has to be an actual violation of law. It's only what they reasonably believe to be legally impermissible. And, you know, I don't even know if there is a difference between something being against the law or being legally impermissible. It's just an unusual use of language. I'll just move on, but I'm going to point out that this language is extremely vague and hard to understand. And I think that I wonder sometimes, I mean, how much the trial lawyers are contributing to, you know, the way we write our bills in here, because they end up being litigated so much more often. And that it's not by accident that we have terms like reasonably believed. That's just an invitation to create litigation so people can argue over what that means. And there's no reason for that. We could easily state in these bills what we mean. It also on line 324 refers to work related events. The chairman left the dais for a moment. I'll pause.
Please continue.
Thank you, Madam Chairman. I was moving on from my confusion over the terminology legally impermissible. For example, instead of simply stating the word unlawful, which we see most regularly in a statute, on to line 324, where it refers to work-related events. Can you describe for me what a work-related event is? And is there some sort of distinction that what makes something work-related or not work-related? If you are invited to a retirement party after hours, for example, is that a work-related event for you?
Yes, in my opinion.
Thank you. And if it's just a few of the employees getting together to watch a game or something on the weekend, is that a work-related event through you?
It could be. I think it would depend on the circumstances.
Just for legislative intent, maybe you can describe what some of those circumstances might be.
Sure. If, say, the employer through its newsletter or bulletin boards or other means informed employees of going over to somebody's house to watch a game, that might in fact be a work-related event.
Is the distinction that they're actually discussing or doing work at this event?
I don't think that a work-related event needs to necessarily discuss work. I think that employers often have events that they organize or that they condone or that they put forward for people in the work environment to spend time together doing things other than discussing work. And I think that would be considered work-related.
Thank you very much. Madam Chairman, so are you suggesting that it would have to be organized by the employer?
Not necessarily.
Thank you, Madam Chairman. The reason I'm asking this question is because every time I ask, this definition gets broader in my view. You know, it's like work-related event. Well, now it sounds like it doesn't have to be organized by the employer. There doesn't actually have to have any work involved. It sounds to me like it's anytime one or more of the employees is together with another employee, that sounds like a work-related event. Would I be wrong, Madam Chairman?
I think I answered the question to my best of my ability, and I think that CHRO would determine whether it was work-related. But in my understanding of this, in my way I think of this as chairperson of this committee and as someone who has been in the work world most of my life, a work-related event could be something that was organized by someone other than the employer, but was advertised and promoted by the employer.
Thank you, Madam Chairman. Again, I don't mean to keep asking you all these questions, but I'm in disagreement with you that this should be decided by CHRO. In my view, this ought to be in the statute. And we have enough of this empowering bureaucracies. The bureaucracy doesn't get to make the law. We have a constitution in the state that says the legislature makes the laws. So the interpretation of the law should happen in a courtroom. It shouldn't happen in CHRO, but that's another battle we can fight on another day. But the idea that anybody should be forced to have to make these decisions is a failure on the part of the legislature to put enough clarity into the statute. So that's why I'm kind of trying to get some clarity from you what this actually means. So you just mentioned that it could be an event that is organized by employees, but advertised by the employer. Is that required also? And I'm going to just, instead of just asking you 100 questions, let me just get to the bottom line here. We already said that a retirement party, you know, for somebody who works at the company could definitely be a work event. And the employees getting together for the game over the weekend could be a work-related event depending on what happens there. So, and what is when does it not a work-related event when you have two employees of the company together? Through you.
I don't think I can, I don't want to imagine every possible interaction that could occur between two employees of an employer and tell you what would be and what wouldn't be. And I do think that it is impossible to do that. And I think that's why we use these terms in law that can be adjudicated, that can be investigated and determined by a neutral party.
I appreciate that. And I can understand you don't want to give me every example that may or may not be a work-related event in that circumstance. But can you give me one situation?
I don't.
Where-
Oh, I'm sorry. I interrupted. Please proceed.
Can you give me one example where you have two employees that are together outside of work that is non-work related?
I don't want to speculate.
Would this mean that, you know, you have folks that work for the same company and they become involved in a relationship? Would that be considered to be a work-related event when they went out to, you know, dinner or to the movies?
I can only tell you, I would not assume that it was work-related
Thank you very much.
without knowing anything more, I should say.
Thank you, Madam Chairman. And I appreciate that. Again, I'm just pointing to how difficult these questions are. And we're just scratching the surface of the potential of things that could be brought up down the road in a CHRO hearing, for example, and potentially putting a employer in an incredibly difficult position. That there are, in fact, fines for, which we'll talk about in a second. But for me, to ask an employer to be responsible in such unbelievably broad terms in situations that they have little control over. You know, me and the staff attorneys get together to watch a football game this weekend. Is it a work-related event? You know, did we at one point stop in the middle of the game and say, hey, by the way, wasn't that funny when we were talking about the NDA bill? You know, is it suddenly work-related? Was it not work-related because we never talked about business? I mean, you're putting an unbelievably vague set of terms in front of a regulatory body that effectively is the judge, jury, and executioner sometimes. You don't even have a fair hearing there. Just moving on, the penalties. This bill imposes a minimum penalty of $10,000 per violation. Is that correct, Madam Chairman? That's what I wrote down, but I don't know that I have that section in front of me.
I believe it's at least $10,000, yes.
So $10,000 is the penalty. And what would an employer have to do to have to experience that penalty?
I'm sorry, what is the question?
Through you, Madam Chairman, I'm just asking you to repeat what this bill imposes this violation and penalty for.
So a violation of this statute, the way it's drafted now and before us, would an employer who violates the statute would be liable for $10,000 if found in violation.
Right. I was hoping that you might be willing to, just repeat some of the provisions that are throughout this bill. But again, you don't have to. We've kind of covered it. We already know that it's based on what the employee reasonably believes. We know that the circumstances will be liberally construed. And we also know that work-related could mean almost anything. And legally impermissible is chosen instead of the word unlawful to create some sense of question in there. And my next point is that this bill is obviously chilling on business operations and settlements. I think that businesses are going to be a lot less likely to try and settle any kind of dispute if confidentiality can no longer be assured. I think that employers might be even more hesitant to hire employees or contractors who pose a litigation risk because of such a thing. Again, when you start to create policies like this, much like in the Housing Committee, you got bill after bill that is imposing new restrictions on landlords, and then people shake their head and wonder why there's less housing available. Here, we're telling employers, we're going to make your job that much more difficult. We're going to make it that much more complicated for you to stay in business because there's a minefield out there of loosey-goose language passed by the Labor Committee that might get you in trouble and run afoul of the law, even if you were trying to do everything the right way. I think this bill gives no consideration to good faith employer actions. I think they are at risk for excessive penalties based on what can sometimes be very minor disputes that could be resolved very simple. And then, I'm just going to close with this comments about speech. I talked about the violating the rights of the employee to engage in a contract of their own free will and accord when it comes to wanting to engage in an NDA. But this effectively creates a situation of what I would consider to be called compelled speech, which is kind of the opposite of free speech. It's like a situation where you're being forced into a situation to say certain things, whether you agree with them or not. And I think that it creates compelled speech by preventing employers from contractually limiting any potential disparagement from an employee. And I think that that's a problem because employers should have a right to protect their reputation, and restricting their ability to negotiate a confidential agreement violates, again, contract law, as I already mentioned, but I think it also violates their right of free speech. This bill, I barely touched the surface with the language that's in the bill and how each one of the paragraphs throughout can cause a significant potential danger to people that are good people that are just trying to, operate in an honest fashion. And it does so by violating the rights and freedoms of the parties and the people that we represent. And for those reasons, Madam Chairman, I just can't support this legislation. And I really caution this committee not to violate the rights of the people that we represent to engage in their own free will choices, including when an employee feels it's in their best interest to engage in a non-disclosure agreement. Because that's what this bill does at the end of the day. You may be right that it is restricting employers from hiding bad actors and so forth, but that only happens at the choice, the freedom of the employee to engage in that non-disclosure agreement. And denying them that right is not going to be beneficial, because to me, that right belongs solely to them. It doesn't belong to the Labor Committee or this legislature to limit or eliminate. They should have that right. Thank you.
Any other comments or questions? Seeing no hands, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 2, Senate Bill 1035, an act concerning limitations on the use of non-disclosure agreements. This is a motion to JF to the floor. Senator Kushner,
Yes.
Representative Sanchez, Senator Cabrera, Representative Wilson,
Yes.
Senator Sampson,
Sampson is no.
Representative Weir,
Nope.
Representative Hall, Representative Hughes,
Hughes votes yes.
Senator Lesser, Representative Canino,
No.
Representative Gauthier,
Gauthier, yes.
Representative Mastro Francesco, Representative Shake. Thank you, Madam Chair.
Thank you. We'll take a brief pause to determine how long we're going to be holding votes open. We will be holding votes open until 4 p.m., at which time votes will be closed and the meeting will be adjourned. Thank you all. There's the next meeting of the committee will be on Thursday, the 20th at 9 a.m. 9 a.m. Okay. Thank you all.
Okay. Good afternoon, Representative.
Hi, how are you?
Doing well. So we missed 4, 5, 6, 7, 8, 9, and 2 on the agenda.
Oh, number one I did, right?
Correct.
How about number two?
Yeah, number 2 you missed. Do you want me to read it out?
No, I missed that one, right?
Correct.
Okay, so I'm a no on number two.
Understood?
Number three, they held that one, right?
Correct.
Okay. 4, 5, 6, 7, 8. And 9,
So-
I'm no's.
You know on 4, 5, 6, 7, 8, and 9?
Yep.
You got it.
Good, thank you.
Have a good day.
Until bye.
Come on down.
I had to jam the bill for putting.
Hey, everybody. Good afternoon, Representative. We have votes open.
Good afternoon.
Do you want me to read off the agenda items or do you
Can you
have
hear
them?
me?
I can, yes.
I have them. I have them.
Okay, so for agenda item
So
1,
I'm a yes on all. If,
you're a yes on
unless
all of
we
them?
have to go-
Did I hear that right?
Yes.
You got it.
Yeah.
Thank you, Representative.
Take care.
Take care.
All right, bye.
Good afternoon, Representative.
Hughes votes yes on item 6.
You got it.
Thank you so much.
Thank you. Good afternoon, Senator.
Hi, how are you? I guess I missed one.
Yep, it's 6517.
Senator Cabrera votes yes.
You got it. Thank you.
Thank you.